Yes.
May I please, Lord? My Lord, item number 7, my Lord. My Lord, and I am, my Lord, just now they filed an objection, my Lord, after 5 minutes before, my Lord, my respondent, my Lord. Item number 7, my Lord. There is a delay, my Lord, delay is there, my Lord. So today they filed just their objection, my Lord. So may I pray this matter be fixed another date for hearing, my Lord. This, my Lord, convenient, my Lord, December 9, December.
Who's for the other side?
My brothers.
What do you say?
We will be filing the written objection within the course of the day, my lord. We already served the copy.
Okay, you have served a copy in advance. You have not filed.
We are about to file, my lord. Yes.
Okay, you've got an advance copy.
Yes.
When do you want it?
My Lord, 9th of December, my Lord, if they,
What do you say?
My lord. That no issue.
Mr. S.K. Mehdi, learned counsel for the applicant, submits that he has received a copy of the objection to the condonation of delay application and prays that the matter may be listed on 9th of December 2024 for consideration. Stop. Mr. F. Lengliana, learned counsel for the respondent numbers 1 and 2, submits that the objection is going to be filed during the course of the day. And he has no objection if the matter is taken up on 9th of December. Stop. Next para.
sorry,
In view of above, list the matter again on 9th of November 9th of December 2024 as paid for. Yes.
Please, Your Lordship, if I may be allowed to mention item 9 and 10, they're clubbed together, fixed for hearing today. If these matters may kindly come up in the coming week, I've taken the consent of the respondents.
Mr. Dentrima,
Item number 10, my lord.
any objection? On the prayer of Mr. A.R. Malhotra, learned counsel for the appellant in RFA number 29 of 2022. Okay, both are your case.
Yes, both are clubbed together.
Counsel for the appellants. Don't put the number. On the prayer made by the learned, on the prayer made by Mr. A.R. Malhotra, learned counsel for the appellants, and not objected to by the opposite parties. This is the matter for hearing in the week commencing from 4th of November 2024.
I'm over.
May it please us, Your Lordship? I would like to make a mention of item number 12, my lord.
Yes.
The petitioner no longer wants to pursue the matter, my lord, as he has a job elsewhere. So with Your Lordship's permission, if the case may kindly be disposed of as not being pressed.
Ms. Valentina Laldinpui, learned counsel for the petitioner, submits that on the instructions received from her client, she would not like to press the writ petition. Stop. Mr. L.H. Interim, senior counsel, appears for respondent number 3 and 4, and Mr. Zoram Sana, learned counsel, appears for respondent numbers 1 and 2, and they have no objection if the matter is disposed of as not pressed.
Much
In view of above, the writ petition stands disposed of as not pressed.
obliged.
Lordship, item 11 of the hearing. Lordship, I was appointed as a legal aid counsel for the respondent, Your Lordship, in this regard. Then I have received a copy of the RFA from the appellant, Your Lordship. So this may be kindly taken up after
J.H. Ramnemoya, who is the engaged counsel for the appellant, he has requested me to make a mention on his behalf.
as he's undergoing preparation for examination in MJS. So after the examination probably
So when do you want it?
by the end of November. By the end of November, yes. Yes. The last week of November.
As paid for on behalf of Mr. J.H. Ramne Moya, learned counsel for the appellant, not objected to by the other side. The matter stands adjourned for three weeks. Stop. Mr.
Johnny L. Tauchung.
You are the legal aid counsel.
Legal aid counsel, yes, I was appointed.
Mr. Johnny L. Tauchung, learned counsel, submits that he has been appointed as the legal aid counsel to represent the sole respondent.
Yes.
Stop. In view of above, office to reflect the name of Mr. Johnny L. Tauchung as the legal aid counsel for respondent number, for the sole respondent in the cost list hereafter.
Obliged.
Yes.
For orders, item number 6.
Yes.
May it please your lordship. My lord, this instant bail application has been filed as the instant accused appellant was arrested on the 28/7 of 2022 at around 10 a.m. at Dapswa near Tooth Bridge in connection with seizure of 2.085 kgs of suspected heroin from one motor vehicle, Tata Harrier, which is a Tripura registration bearing TR 01BQ 0507. My lord, the instant petitioner, accused petitioner was arrested along with 5 other persons. However, my lord, during the course of the investigation, the 3 persons, if your lordship could kindly come to page number 11, annexure 1, this is the charge sheet.
Yes.
My lord, at column number 3, the name of 3 persons have been reflected. And these 3 persons, even though they were initially arrested with the accused petitioner, they were, however, no charge has been framed against them and they were released, my lord. The first person, Biswajit Devnath, my lord, according to the instant charge sheet, he has traveled to explore Mizoram. And number 2, Haijel Ahmed, which is reflected at column number 3, he was also, according to the charge sheet, my lord, he was used as a scapegoat. And the number 3, Abdul Muqtadir, who is reflected at column number 3, he was staying at the hotel in Champai along with the accused person. So, my lord, that is why these 3 persons were arrested initially. And, my lord, the instant petitioner is the driver of the vehicle that was seized.
Yes.
My lord, charge was framed by the learned trial court on the 9th February 2023. On the 9th February 2023,
Yes.
under section 21C, read with 29 of the NDNPS Act.
Yes.
And, my lord, till the time of filing of the instant bail application, 7 out of the 10 cited witnesses, only 7 out of the 10 cited witnesses have been examined, and the PW number 9, PW number 9 was dropped.
So, how many remains? 2 remains.
2 remains. 2 remains.
Who are they?
My lord, these are PW number 7, Biswajit Devnath, and PW number 8, Haijil Ahmed.
This accused persons who were not sent up for trial.
Yes, my lord.
Trial.
My lord.
Serial number 1 and 2.
Yes.
These are the two witnesses.
Yes, my lord.
When is the date fixed?
My lord, the next date has been fixed on the 30th
Of?
of this month, tomorrow, my lord.
Okay.
And
Who's going to be examined?
PW number 7. PW number 7, Biswajit Debnath.
PW7 is going to be examined.
Yes, my lord. And my lord, my limited ground at this stage of for bail application is that, my lord, the instant accused petitioner has been detained, has been in prison for more than 2 years. That is 2 years and 3 months, 824 days to be exact, my lord, as on date, as on today.
Yes.
And that, my lord, it seems that the trial is not likely to be completed very soon, because the two witnesses that have been yet to be examined, they are from outside the state. They are from Tripura. And,
So?
and my lord, my limited ground at this stage is that
There is no connectivity of Tripura and Mizoram.
my lord, it may take some time, my lord. And my lord, my limited ground is that the instant accused petitioner have been in prison for more than 2 years, and the trial is not likely to be completed very soon. My lord, there is it is settled that the rigors of Section 37 of the Indian PS Act cannot abridge the right to life as enumerated under Article 21 of the Constitution of India. So, my lord, in this my lord, I would like to submit two judgments.
Yes.
This is passed by the Honorable Supreme Court in Ravi Prakash versus State of Odisha. Petitions for special leave to appeal criminal number 4169 of 2023 at paragraph number 4, my lord. Paragraph number 4, if I may read,
Just a minute.
my lord.
Yes, read.
Paragraph number 4.
Yes.
As regard to the twin conditions contained in Section 37 of the Indian PS Act, Learned Counsel for the respondent state has been duly heard. Thus, the first condition stands complied with. So far as the second condition, formation of opinion as to whether there are reasonable grounds to believe that petitioner is not guilty, the same may not be formed at this stage when he has already spent more than 3.5 years in custody. The prolonged incarceration generally militates against the most precious fundamental right guaranteed under Article 21 of the Constitution, and in such a situation, the conditional liberty must override the statutory embargo created under Section 37(1)(b) Roman II of the Indian PS Act. My lord, to further substantiate my case, I would like to place another order passed by this honorable court in bail application number 1195 of 2023, passed on August 2nd, 2023. I would like to rely on paragraph number 12. If I may read, paragraph number 12. Though this case involves commercial quantity of methamphetamine weighing 907 gram. And charge has been framed against the present petitioner under Section 22C of the NDNPS Act 1985 on 13/12/2021. And apparently the embargo of Section 37 of the NDNPS Act 1985 appears to be applicable in the instant case. However, the present petitioner is detained behind the bar since last 10/08/2021, 720 days, that is 1 year, 11 months, and 21 days. And the evidence on prosecution witnesses is yet to complete. It also appears that on 22nd/05/2023, summons were issued by the trial court to the last prosecution witness, that is the investigating officer. However, the investigating officer remained absent on 3 consecutive days. Thereafter, the next date for examination of investigating officer is fixed on 24/08/2023. It is also pertinent to note that out of the 8 prosecution witnesses, 7 have become hostile and have not implicated the present petitioner, considering the fact that the Honorable Supreme Court of India had observed in Muhammad Muslim Hussain versus State and City of Delhi, Supra, that grant of bail on ground of undue delay in trial cannot be said to be fettered by Section 37 of the Act. And also considering the observations of the Honorable Supreme Court of India in so-and-so, to the effect that prolonged incarceration generally militates against the most precious fundamental right guaranteed under Article 21 of the Constitution, and in such a situation, the conditional liberty must override the statutory embargo created under Section 37(1)(b) Roman 2 of the NDNPS Act 1985. If this court comes to a finding that there is undue delay in completion of trial and there is prolonged incarceration of the petitioner, he would be entitled to get bail on the ground of prolonged incarceration only as in case of such prolonged incarceration, the right to life and personal liberty under Article 21 of the Constitution of India would outweigh the fetters imposed by Section 37 of the NDNPS Act 1985. The Honorable Supreme Court of India in so-and-so had granted bail to the accused on the ground of prolonged incarceration of 1 year, 6 months. Similarly, in Nityash Adhikari versus State of West Bengal, the Honorable Apex Court granted bail to the accused facing accusation under 21C of the NDNPS Act 1985 on the ground of prolonged incarceration of 1 year, 7 months. As such, in the instant case, when out of 8 of the prosecution witnesses already examined, 7 of them have become hostile and the investigating officer has not turned up on last 3 consecutive dates, in spite of issuance of summons to him, and the present petitioner is languishing behind the bars since 720 days, that is 1 year, 11 months, and 21 days. He is entitled to get bail only because of the fact that trial has not yet completed in spite of prolonged incarceration. So, my lord, to sum up my case, my lord, the instant accused petitioner has been behind bars for more than 2 years, 824 days, and that, my lord, trial is yet to be completed, and it is unlikely that it will be completed soon. So, my lord, in such a situation, I humbly submit that this Honorable Court may kindly grant bail to the instant accused petitioner, my lord.
Any information regarding how many times this Bishwajit and Hajal Ahmed have been summoned, or this is for the first time?
My lord, the last witnesses who were called on were examined on 5th September 2024.
Who was that?
This was the PW number 6.
Dalmohan Omar,
My lord.
the FSL.
Yes, my lord.
Okay. So that means the PW 7 and 8, or 7 as of now, has been summoned for the first time.
My lord.
Okay. Anything else?
No, my lord.
All right. Yes, PP.
My lord, this bail application, it involves a commercial quantity, and
This is the first bail.
Yes.
Was there a bail application before the trial court?
Yes, my lord.
Rejected.
Yes, my lord.
It was rejected.
When was that?
My lord,
29
it was
July.
rejected on 29 July.
Of this year?
Yes, my lord.
Okay.
29 July 2024.
Page?
My lord, this is at page numbers 16 and 17.
Okay. Okay. Yes, Miss.
Yes, my lord.
Eric.
My learned friend have cited some other grounds in his petition, but then I will limit to his limited prayer only, to my argument. I will limit my argument to his limited prayer only. My lord, in this case, the fact that is there on record before us is that this present petitioner Jayanta Das, he knew that he possessed the heroin seized articles, my lord. And he confessed it in front of the witness number 3, 4, 7, and 9. And the witness that is cited in the charge sheet, that is 7, 8, and 9, 3, 4, 7, 8, 9. My lord, they are yet to be examined, 7 and 8. And now the position is clear. Conscious position is clear. Their only limited prayer is that the incarceration behind the jail is more than 2 years. And my lord, the rigors of Section 37 of the Indian PS Act, even though in bail application, in some cases, there might be a time when they are allowed to go on bail. But then, my lord, my learned friend have cited 2 cases. Number 1 is the SCC, wherein the jail time that is put in by that petitioner is 3.5 years. Now, that is not the case of the present petitioner. And my lord, in the second case, that is 1 year, 1 month. But then in that case, they were allowed to go on bail because even though someone was affected upon them, then they did not appear. So the fact situation in those cases is not the same with the fact situation in the present case, my lord.
Okay.
And my lord, as far as my humble knowledge and opinion, my lord, the trial is going on smoothly. Now, only the witness number 6 was, as stated by my learned friend, was examined in the month of September 2024. Now, this charge sheet was submitted in the year 2022, and only the remaining witnesses, that is 7, 8, and 10, are remain. My lord, so considering the nature of the offense that is charged against the petitioner, my humble prayer is not to release the petitioner on bail, because the position is clear, and second is that even though they are the citizen of India, then they are not from Mizoram. And then we have lots of cases wherein the accused have absconded and could not be fined.
Who remains to be examined? 7, 8,
7, 8, and 10, my lord.
10 also.
Yes, my
Mr.
lord.
Zakima, 10 also.
My lord, even though it's not reflected in the charge sheet, my lord, as per the records, the PW number 10 was also examined on the September 5th,
Along with?
along with PW number 6.
Oh, okay. Okay.
Okay.
So that makes it more simple. Only 7 and 8 remains. And my lord, the bail application was submitted before the learned trial court, which was duly rejected on 29/7/2024. Now, that is in Annexure 5, my lord. Here also, the learned trial court have stated that there is a conscious position, my lord. So, my lord, it is my humble prayer that at this stage, the bail application be rejected, my lord.
Do you have any materials? Like the statement of the witnesses already examined?
That I do not have, my lord.
Shouldn't you have that? See, somebody has filed a bail application. To oppose that, you may not like to file a written objection, but at least you should have some of the evidence recorded
Yes, my lord.
and support your submission. Now, basically, you're relying upon the bail application itself to object it. At least you're expected to have some proper instruction. This is the evidence of the IO. This is the evidence of this person. From this document, you can see that he is very much aware of the fact that he's carrying this contraband substance like that. Now we are just basically relying upon the rejection of bail application order. Okay, anything else?
That's it, my lord.
Heard? Please write heard Mr. T. Lal Zakima, learned counsel for the petitioner, who submits that by filing this application under section 480 and 528 of the Bharatiya Nagarik Suraksha Sanhita, 2023, read with section 37 of the NDNPS Act, prays for release of the, please read the sentence which I have just dictated from the beginning. We'll do one thing. We'll do one thing. We just cancel. Just take your seat. Cancel the entire thing. From the beginning. Heard Mr. T. Lal Zakima, learned counsel for the petitioner, and Miss Mary L. Khyangte, learned additional PP for the state respondent. Stop. On 14/10/2024, court passed the following order. Please abstract it. Next para. Today, when the matter is taken up for consideration, Mr. T. Lal Zakima, learned counsel, submits that the main thrust of his argument is that the petitioner has been incarcerated in jail for 824 days as on today. And that the trial is yet to conclude. Stop. Therefore, on this ground alone, the petitioner should be released on bail. Stop. He submits that out of the 10 prosecution witnesses, 7 witnesses have already been examined. Stop. PW9 has been dropped from the arrayed witnesses, and what remains now is the examination of PW7 and PW8. Stop. He submits that PW7 is scheduled to be examined on 30/10/2024. Stop. Nevertheless, having regard to the long incarceration of the petitioner, court may release the petitioner on bail pending finalization of the trial. Stop. In support of his submission, the learned counsel relies upon the following authorities. Number 1, order dated 13/7/2023, passed by the Supreme Court in SLP bracket criminal number 4169/2023, open bracket, Rabi, R-A-B-I, Rabi Prakash versus State of Odisha, close bracket. And number 2, order dated 2/8/2023, passed by a coordinate bench of this court in bail application number 1995/2023, bracket, Asab Uddin versus the State of Assam, close bracket. Stop. Next paragraph. Per contra, P-E-R, per contra, Miss Mary L. Khiangte, learned, additional PP, submits that the amount of heroin alleged to have been recovered from the possession of the petitioner is 2.085 kilograms, which is a commercial quantity. And having regard to the rigors of Section 37 of the NDNPS Act, the petitioner has to satisfy that the twin conditions prescribed therein are not attracted. Stop. However, from the order dated 29/7/2024, passed by the Learned Trial Court in bail application number 435 of 2024, it can be plainly seen that the alleged heroin that was recovered was in the conscious possession of the petitioner, and that the petitioner, if enlarged on bail, is likely to commit an offense of similar nature. Stop. With the observation made by the Learned Trial Court, it is clear that no case has been made out by the petitioner for grant of bail. Full stop. She further submits that out of the 10 prosecution witnesses, one of the witness, that is PW 9, was dropped, and only PW 7 and 8 remains to be examined. Stop from the submission made by the learned counsel for the petitioner itself. It appears that PW 6 and PW 10 were examined only last month. That is on 5/9/2024. Full stop. Therefore, there is no delay in the conduct of the trial. Full stop. She further submits that the authorities relied upon by the learned counsel for the petitioner are clearly distinguishable in view of the fact that the prosecution witnesses in the case referred to failed to turn up despite issuance of several summons, and that the accused person concerned was said to have been kept in jail for over 3.5 years, which is not the case in the present application. Stop. She therefore submits that the bail application has no merit and the same should be rejected. Stop. Next para. I have heard the submissions made by the learned counsels for the rival parties, and I have perused the materials available on record, including the authorities relied upon by the learned counsel for the petitioner. First up, the learned counsel has you cancel that from the rewrite. The sole ground on which bail has been sought by the petitioner is long incarceration. That is, the petitioner being in custody for 8 to 4 days as on today, since his arrest. When were you arrested? On 28/7/2022. Mr. Sekima, what is the status of the other accused person? Prasanjit Das?
My lord, he's still in custody.
Okay. Stop. According to the prosecution, the recovery made from the possession of the accused persons, including the instant petitioner, was 2.085 kilograms of heroin. Stop. The same falls under the commercial quantity as per the NDNPS Act. Stop. Section 37 of the same Act provides that bail may be considered to be granted after giving the public prosecutor an opportunity to oppose the bail, and the court on such opposition is satisfied that there are reasonable grounds for believing that the accused person is not guilty of such offense and that he is not likely to commit any offense while on bail. Of the charge sheet filed by the investigating authority goes to show that the investigating officer found a prima facie case well established against the petitioner under section 21 bracket C of the NDNPS Act, and accordingly submitted the charge sheet. Stop. Charge was framed on 9/2/2023 under the said Act, and also under the said Act, you cancel that. Charge was framed under section 21C bracket C, read with section 29 of the NDNPS Act. And the prosecution has lined up as many as 10 prosecution witnesses to prove the charge. To stop, as already submitted by the parties, PW9 has been dropped, and all the remaining prosecution witnesses have been examined, except for PW7 and PW8. I repeat, except for PW7 and PW8. Full stop. The learned counsel for the petitioner has submitted that PW7 has been summoned to be examined on 30/10/2024, which is tomorrow. Full stop. The petitioner may have been in custody since his arrest on 28/7/2022 till date. But the fact remains that the reason for his arrest and being kept in custody is for possession of a commercial quantity of heroin, which please read that sentence, the last part. Possession. Before that possession, you add conscious. Conscious possession of which is not required. You cancel that. Stop. Stop. Therefore, cancel that also. Further, the learned trial court, in its order dated 29/7/2024, while rejecting the bail of the petitioner, had also made an observation that from the materials available on record, it could not be presumed that the petitioner was not guilty of the alleged offense. Next para, the apex court in Ravi Prakash Supra had taken into consideration the fact that the prolonged incarceration, generally militates against the most precious fundamental rights, not without S, fundamental right guaranteed under Article 21 of the Constitution. And in such a situation, the conditional liberty must override the statutory embargo created under Section 37, bracket 1, bracket small b, bracket small Roman 2. However, the fact remains that the facts in that given case was recovery of 247 kilograms of ganja, and that the accused person had already been kept in custody for more than 3.5 years. Further, out of the 19 prosecution witnesses cited, only one witness had been examined. It was under such circumstance that the apex court had made the observation regarding the overriding of the statutory embargo created under Section 37 of the NDNPS Act. Similarly, in the case of Asab Uddin, bracket Supra, the facts in that case was that commercial quantity of methamphetamine, that is 907 grams, had been recovered, and the accused booked under Section 22, bracket C of the NDNPS Act. In that case, the prolonged incarceration was for 1 year and 7 months. Which is lesser than the period of incarceration already undergone in the present case. Full stop. However, from a perusal of the said order, comma, it can be appreciated that out of the 8 prosecution witnesses, comma, 7 witnesses had turned hostile. Stop. Further, the case investigating officer, despite being issued summons, had failed to turn up to give his evidence on the last 3 consecutive dates. Full stop. All these factors taken together apparently persuaded this court to grant bail to the petitioner in that case. Next paragraph. The proceedings and the facts in the instant case, in the considered view of this court, are not similar. Stop. Having regard to the fact that one of the 2 remaining prosecution witnesses is due to be examined shortly. That is, in the very near future. Stop. Therefore, upon due consideration of the submissions made and the materials available on record, this court is not inclined to grant bail. Stop. Accordingly, the bail application stands rejected.
For admission, item number 1.
Lordship, my senior CGC is on left.
She's on legs.
Yes, my lord.
Otherwise, she's ready to argue.
We received an instruction this morning.
Sorry?
May I please, we received an instruction.
Speak on the microphone. Is it
We
working?
received an instruction this morning from the ministry.
You
May
have
I
received
please-
instruction.
Yes, my lord.
What is the instruction?
Government of India has desired to file the review petition before Honorable Supreme Court to review the order dated 4 January 2024 passed by the Honorable Supreme Court in SLPC diary number 43460 of 2019, for which advice of MHA and Ministry of Law and Justice is being obtained, which will require at least 2 months. At least 2 months' time.
Your Worship, they are still in the process of getting advice. No decision has been made to file a review also.
Okay.
And Your Worship, there was a further direction to get the name of the present incumbent, respondent number 1.
You have the name?
No, my lord.
Why?
The case of contempt in the name of Ajay Kumar Bala, the new secretary Ministry of Home Affairs, has no role in the matter. Therefore, the name of the new secretary and his contact number is not relevant for the purpose of the contempt issue in the case.
What is that? No, what is that you're reading? Some written speech? Mr. Malhotra, are you not able to find out the names from your
Yeah.
source?
We can, Your Worship. In fact, we have found out the name through the internet. The new incumbent is Mr. Govind Mohan.
Why don't you plead him?
Ashok, I don't know, somehow in the last order, they were directed to find out the name.
Yes, we had directed, no doubt. But they don't want to stick out their neck.
Ashok,
They'll have to do
in that case, Ashok, is it required to file a written application? I mean, now that we know his name.
Yes, very much. You'll need to file an application.
And Ashok, apart from that, Ashok, at least show cause note may be issued against the respondents 1 to 3. Because as on date, Supreme Court dismissed the SLP in January. In their affidavit, respondent number 1's para 16 had stated that the Union of India has decided to file a SLP. But here now they are saying they are seeking advice. I mean, they are contradicting each other. If your Lordship will kindly see the affidavit filed by the respondent number 1, Mr. Ajay Kumar Balla, para 16 at page 8. In the middle of the page,
What are you referring to?
the affidavit filed by respondent number 1.
Paragraph number? 8. 6.
Para 16.
16.
Relevant page is page 8. Middle of the page. On the decision of SLP, the Union of India has decided to file a review petition before the Honorable Supreme Court, and the review petition is being filed before Honorable Apex Court for review of the order. So they have already decided to file review petition, and it is being filed. But in this letter which my learned friend has produced today,
This is by whom? This is by the commandant, for commandant by the BSF.
Yes, my lord.
in para 2, it is stated, the information on subject contempt petition as desired by your good self on 22/10/2024. In this matter, this unit has approached to our higher headquarter and directed to this unit to apprise you Government of India has desired to file review petition before Honorable Supreme Court to review the matter. Has desired. But in the affidavit filed by the respondent number 1, he says it has decided. I mean, there are two different things. To review the order passed by the Supreme Court, for which advice of MHA and Ministry of Law is being obtained. Here they are saying that advice is being obtained, but in the affidavit filed by the respondent number 1, he says that Union of India has decided to file the appeal. These are very misleading statements made by them.
No, what does it mean otherwise? This paragraph 2? In this matter, this unit has approached to our higher headquarters.
And the higher headquarter has directed them. And the higher headquarter, Yoship, into my understanding, has directed the unit to apprise the central government standing council that Government of India has desired to file, has not decided, it only desires. And they are seeking advice of the MHA. This is the information given to them. Whereas
Ajay Kumar Bhalla is the new secretary.
he is the old secretary.
Then why do they say new secretary? Further, the case of contempt, the name of Sri Bhalla.
There's a full stop there.
But what do you mean by this first sentence? Further, the case of contempt, the name of Sri Ajay Bhalla. Stop.
In the contempt petition, Ajay Kumar Balla was respondent number 1. Since he has retired, they are saying that since the contempt petition is the name of Mr. Ajay Kumar Balla, the new secretary has no role in the matter.
They don't know head or tail what they're saying, Miss Baby. Some officer has written something here for the commandant. He does not know what he's saying. Keeping in view the aforesaid facts as desired by our higher headquarters, you are requested to apprise the
Lordship, my humble prayer before the Honorable Court is to extend the time for 2 months for providing the number of review petition filed before the Honorable Supreme Court to review the order dated for January 2024 passed by the Honorable Supreme Court.
What kind of prayer is that? Who gives that time like that to give you the review number like that? We don't know whether you've filed it or not. We don't know whether you have decided to file or not. Sometimes you say we have decided to file. Sometimes you're saying that we're taking the advice of the MHA in the matter. The matter is quite serious, Miss Baby. It's not, you cannot take it lightly like that. Your officers, they should know, because you have exhausted all the remedy available. Court has passed the order to do something. You have filed an appeal before the Supreme Court. Supreme Court has said nothing is there in merit, we dismiss it. Yet again, you say you want to file a review. And whether you actually are going to file a review or not, that nobody knows. We cannot keep on waiting like that. You represent all the respondents?
No.
One.
Only respondent number 1.
One.
Yes, my lord.
Who are the others?
Yes, Your Lordship, as per the last order, the defect has been cleared by the respondent number 3, the show cause of the respondent number 3. I received yesterday and I'm filing today.
What?
There was one paragraph missing, which shows the mobile number of the respondent. So that has been cleared.
Respondent number?
3.
3.
That has been inserted and we are filing today. We have received
What
the
have you
affidavit.
written in that, your show cause?
The 5 letters which was already mentioned.
Your Worship, all the letters have, in fact, they're in the file.
Yes.
They keep writing to the ministry asking for sanction. They've written, I think, 5 letters. They're all there in the file.
This is the chairman and managing director, the NPCC, correct?
Yes.
So they are supposed to get the fund from the ministry.
Their only statement is that they have written a number of letters to the ministry for asking for sanction. All the letters, in fact, were handed over on the last court day.
What is the order which has been to be complied with?
So that is in the contempt petition. It is-
Solicitation in interest.
yes.
8/11/2018.
Is it page 10? I'm sorry, page 40.
Page 43 is the
43 is the operative.
yes,
Now, this was passed in a writ petition.
yes,
Solicitation in interest.
yes.
Assessment has been done.
Assessment has been done. It has been forwarded to them. In fact, even respondent number 3, 2 and 3 have forwarded the assessment to the respondent number 1.
Respondent number 1.
Respondent number 1 filed his affidavit in August, 27th of August, saying that they have decided to file a review. And 2 months have passed. But till they have not produced any document to show that review has been filed. Here in the present letter, which my learned friend has produced today, here now they're saying they desire to file an review and they are seeking the advice of MHA and Ministry of Law. I mean, now the whole picture has changed. Earlier on, the respondent number 1 says that they have decided to file. Now they're saying they're desiring to file. I mean, the whole picture has changed. From decision being taken, now they're still in the process of taking decision. So, I mean, someone is trying to mislead the court. That is for sure.
Forty-three is the operative.
Yes.
Then, was there any writ appeal?
No, they went straight to the Supreme Court. They bypassed the Honorable Division Bench.
Okay, now where is the assessment?
Assessment, Your Worship, is at page 47.
47.
Of the contempt.
Figures is 616,45077.
Yes.
This is the amount?
Yes. And after this, Your Worship, subsequent to the filing of the subsequent to filing of the contempt petition, the calculation was revised by the collector, which was forwarded again to the respondents.
Where's the revision?
The revision, Your Worship, I do not have a copy of that, but
It became more or less?
it became more.
More.
Yes. And that has been reflected by the respondent number 3 in the last letter
Where is that?
dated 15th of July.
Where is that letter?
5 letters.
Your Worship,
marked
there are
as-
5 letters. I mean, it's not a part of an affidavit. They just handed over to your
It
Lordship.
has been marked as X.
They are all flagged. There are 5 letters which have been flagged. The last letter, Your Worship,
Dated?
15th of July 2024, at the last paragraph, para 5.
858. This one.
Yes, it has gone up.
But where's the covering letter for the award assessment?
No, this is the letter written by the respondent number 3.
Yeah,
To the-
correct. So where's the reference to the modification of the award? Why was it modified?
The wrong calculation, Your Worship.
Any indication anywhere about wrong calculation in this letter? You don't have the copy of the award, the modified award.
The modified award, Your Worship, I don't have a copy.
Why don't you file it if you have
Yes.
a copy? You get a copy and
I'll
file
do
it.
that, Your Worship.
We will take it. We'll take up the matter slowly.
Yes.
They are saying they want to file review. Whether they are filing or not, it's up to them.
Yes, Your.
But we'll get to the bottom of this.
Yes.
First the order of this court, then the assessment,
Yes.
then the reassessment, and some of the letters written by them,
Yes.
and the communication which has come now. On the strength of all these documents, we will consider what is to be done.
Then, Your Worship, in the meantime, we'll file an application for improvement of the new incumbent. Respondent number one, the Secretary, Ministry of Home. And we can also submit a copy of the latest assessment made by the collector.
Yes, let us do that.
Yes.
Please write down, Mr. A.R. Malhotra, Learned Counsel, appears for the, how many petitioners?
Just one.
Appears for the petitioner, while Ms. Baby Laldin Zwali, Learned Counsel, appears for respondent number 1, and Mr. Roshan Subedi, Learned Counsel, appears for respondent number 3.
3.
What about 2? Who is appearing for 2?
2
Has it-
was, this is the incumbent, CMD, the previous CMD. The R.K. Agarwal is the present CMD. So he is replying, he has made this reply.
Respondent number 2 was the previous
CMD,
CMD,
which has been, the
R.K. Gupta.
yes,
Ranjit.
respondent number 2 has been implemented after his retirement.
Now, who is there?
R.K. Agarwal, the present one, which the affidavit which we have filed today.
Respondent number 3 is the
3.
president incumbent.
3. 3.
No, but where's the name?
R.K. Agrawal.
You have not,
He was simply
filed the amended cost title?
We have filed it, Your
I don't get his name, that is why.
R.K.
Okay.
Agrawal.
Agrawal.
R.K. Agarwal.
Agrawal.
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 Yes.
Very easy to confuse with Agarwal. Agrawal.
Next para. The present contempt petition is filed for alleged disobedience of the court's order dated 8/11/2018, passed in WPC
156 of 2000.
number 156 of 2017, whereby a direction was given to the district collector concerned to make an assessment of the solatium and interest entitled to the petitioners. Oh, there were many petitioners. Why only one petitioner today?
Your Worship, in the contempt only one has come forward. There are so many of them, Your Worship. And now, I mean, there are so many details which have to be given in the.
So his particular share was how much? This includes the share of everyone.
Yes, Your Worship.
6 crores now, which has turned to 8 crores now.
Yeah, an extra 5, Your Worship. An extra
Yes.
5 is the assessment. 6 crores, 16 lakhs at page 65.
I've seen that. 65, what is 65?
No, the petitioner's name appears at serial number 296. His share comes to Your Worship,
296.
serial number 296,
What is his name?
Juda Muni.
He's the only one who's come.
Yes, he's the only one who's come.
Why is that?
Your Worship, since there were so many petitioners and to get all the details, we decided that one is enough. One can represent him. His share is,
No, how do you segregate his share?
it's mentioned in the award, Your Worship. Serial number 296.
Comes to how much?
The last column, Your Worship.
131?
Yes,
891?
yes.
This is what? 1 lakh.
1 lakh 31,800. This is as per the assessment dated 15th of July 2019.
How many petitioners were there otherwise?
Otherwise, Your Worship,
321.
21.
They should all come, Mr. Malhotra. Why only just one? We cannot just segregate the award. And all the rest cannot hang on the benefit to be received by the instant petitioner.
Yes, because if the award is satisfied, I mean they have to satisfy the whole award.
Correct. But nevertheless, petitioners were 300 plus in the writ petition. Award was made for so many crores, 6, 8 crores. Now only one petitioner whose share is basically just 1,30,000 has come. You should consider
Yes,
bring them.
yes, Your Honor.
They can authorize one person and he can file on behalf of everyone. What did I say last? No, you cancel that. What is the beginning part? Before that. Okay. Then you read the present contempt petition. Okay, continue. In terms of award number 2 of 2009. Stop. The district collector was also directed to determine the entitlement of the petitioners in terms of section 34 of the LA Act. Stop. The entire exercise was to be completed within a period of 2 months from the date of receipt of a certified copy of the order. And the amounts so assessed were to be deposited for payment to the beneficiaries within a period of 3 months from the date of receipt of the award of the collector. Next para. Against the said order, the Respondent Union of India approached the Supreme Court of India by filing SLP C number 43460/2019. And the Supreme Court provide. Where's the order? Provide order dated 4/1/2024. Dismiss the SLP. Stop. The respondent number 1 has filed a show cause reply to the contempt petition wherein at paragraph number 16 a statement has been made that the Union of India has decided to file a review petition before the Supreme Court of India against the order dated 4/1/2024. And therefore, till disposal of all available remedies, it may not be constituted as contempt of court. Next para. Today, Ms. Baby Laldin Zuali, learned counsel for respondent number 1, has produced a letter dated 28/10/2024. What do you mean by DC? Deputy Commandant? DC oblique adjutant. Okay. Has produced a communication dated 28/10/2024, written by the Deputy Commandant/Adjutant on behalf of the Commandant 163 Battalion BSF. Wherein at paragraph number 2, it is stated that the Government of India has desired to file a review petition before the Supreme Court against the order dated 4/1/2024, and for which, the advice of the Ministry of Home Affairs and Ministry of Law and Justice is being obtained, and which will require at least 2 months' time. Stop. Next para. From the stand taken by the respondent number 1 in his affidavit filed on 22/8/2024, the instructions received by the learned counsel for respondent number 1 through the letter dated 28/10/2024 only appears to be contradictory, since according to the author of the letter, decision has not yet been finalized, as the view of the Ministry of Home Affairs and the Ministry of Law and Justice is being sought. Full stop. Next para, Mr. Roshan Subedi, learned counsel for respondent number 3, submits that the irregularities in the affidavit of the respondent number 3 proposed to be filed has been rectified, and that he will be able to file the affidavit
Today.
within the course of the day. Next para, Mr. A.R. Malhotra. No, cancel that. It is further seen that the instant contempt petition has been filed by a single individual
Writ petitioner number 296.
who was writ petition number 296 in WPC number 156 of 2017.
We were of the view, Your Worship, that it will have the same effect.
Stop. On the other hand, there were as many as 321 writ petitioners in the said writ petition. Stop. The learned Mr. A.R. Malhotra, the learned counsel for the petitioner, submits that they were of the view that filing of the instant contempt petition by a single individual who was one of the writ petitioner in the earlier in one of the writ petitioner in WPC number 156 of 2017 would suffice and would serve the purpose. Stop. However, it is seen that the amount that has been worked out as directed by this court by the amount that has been worked out by the district collector as directed by this court is rupees 6,16,45,077, which has further been revised to an amount of rupees 8,58,11,747. which can be seen from the communication dated 15/7/2024, written by the respondent number 3. Respondent number 3 over. Executive Director. What is his designation?
Respondent number 3 is the CMD.
So he's the MD, Chairman MD.
Chairman come member.
So it should be written by the Executive Director, NPCC Limited, to the Director, bracket, BM-Roman 3, Department of Border Management, Ministry of Home Affairs, Government of India, New Delhi. We'll stop there. For the petitioner may, the learned counsel for the petitioner may consider they, all of them are your clients, isn't it?
Yes. The main problem is, Your Worship, they are from the extreme south.
But somehow you could file the writ petition.
That is the
So same process can be done for your benefit, because ultimately we don't know. Things will get delayed. May consider bringing the remaining writ petitioners on record. Stop as paid for by the learned counsel for the petitioner. The petitioner is allowed to file an additional affidavit to bring on record the revised assessment made by the district collector. Stop the respondent number 3 may also file the show cause reply within the course of the day. Stop the learned counsel for the respondent number 1 shall obtain up-to-date instructions on or before the next court date, and depending on which court may consider passing appropriate orders. What about the new incumbent?
We'll file an application.
No permissions required for that.
Yes.
You can just file. List the matter again.
Can we,
2 weeks.
25th of November?
Your Worship, in fact, now it's for me to take steps.
Yes.
I'll do the needful within 2 weeks.
2 weeks. List the matter again after 2 weeks.
Item number 2.
May it please your lordship. My lord, I have received the amended writ petition today. My lord. May I be
May it please your lordship.
Yes.
Lordship, we're in the process of filing the consolidated writ petition today, your lordship.
I only pray for a slight liberty to file any additional affidavit for clarification purposes if required.
No, where's the, you're going to file or you have already filed?
Lordship, it's in the process, lordship. We've served a copy upon the respondent.
You have received a copy.
I've just received the copy today in the morning. So let it come up on 26th of November, my lord. In the meantime, if I have to file an additional affidavit in clarification, I will do so.
Yes, when are you filing your recast petition? Today?
Today, your lordship. Today.
What is your good name?
S. Kataki, your lordship.
Miss S. Kataki, learned counsel, who appears through VC, submits that the recast / amended writ petition will be filed during the course of the day. Stop. Mr. N. Barwa, Learned Counsel for respondent number.
For the respondents, all the respondents.
Learned Counsel for all the respondents submits that he has received an advance copy of the amended writ petition and prays that he may be given some time to file additional affidavit in opposition. Prayers aloud. Next para, list the matter again on 26th of
Lordship.
November 2024. As per
Lordship, there's an interim order.
interim order passed earlier shall continue till that date.
Highly object.
Oh, yes. How many matters are there? Yeah, we'll come back. I think there's some hearing also is there. I'll come back in 5 minutes.
Hello.
Item numbers 3 and 4.
Your Lordship, in these two cases, due to certain personal difficulties, Your Lordship, I could not prepare as well as I would like to because I was a little bit busy, caught up with some other matter before the division bench. So my humble prayer is that if the matter may be passed over just for a day, I believe there'll be a single bench tomorrow.
What are the matters?
It's about that cess, Your Lordship, the cess in that Mara Autonomous
MADC.
District Council.
The opposite party has to take instruction.
That I've taken, that I have.
What is the instruction?
The instruction, Your Lordship, was that by virtue of that notification, Your Lordship wanted to find out whether similarly situated persons have also been, 10% cess, whether they have been deducted as well also. So I have, these are two orders of the DC wherein cess have been deducted. So Your Lordships, I believe query was whether cess was deducted only in the case of the petitioners or has it been done in other cases as well. So that is in respect of two situation.
Okay.
What is this 3G thing?
3G is that under National Highways Act. 3G is the final award under the National Highways Act. Equivalent of Section 11 of the old LA Act.
Notification of 30/9/2019 has been referred to.
Yes, Your Lordship, Annex 3 of in this also, they have wrongly deducted cess. Well, the road is
Where's Annexure 3?
central. Annex 6 of the writ petition number 60 of 2013.
60.
Page 68.
68, Annex 6.
Notification is dated 23rd of September 2019.
Yes.
But in this order which Mr. Fakoma has produced today, reference is made to
Maybe wrongly.
No, my lord. That the reference that 10/10/2019 can be found at page 21 of the affidavit of the state, respondent number 3 and 4. It's basically an order of the DC pursuant to that 23/9 notification.
No, you have a copy of the order with you, which you just handed over.
I've given a copy to my learned friend.
Yes, out there, you just see that order.
Understood, Your Lordship. The order mentioned
3919. What is this?
30.
3919. Notification memo number so and so so and so.
Yes, that can be found in the affidavit of the state respondent. 3 and 4.
In which case?
In the same case, in the 60 of 23,
At page number
20,
20.
20.
Yes.
So it's
39.
similar to this previous one in continuation.
What is the difference between these two? 23.9 and 13.9. In continuation, okay.
So it's basically reiterating, I believe.
So in the writ petition, what has been challenged? The 23 one,
No,
23.9.
This 23.9 has not been challenged.
Your Lordship, it's not applicable to this case. You have mentioned that. Your Lordship, the query by this court is that annexure, kindly see annexure 5, that is page 60, 23. Land and Revenue Act, MADC.
Yes.
Kindly see page 66.
66, yes.
Yeah. Here, the query of this court is that whether the district council has take cess other than land acquisition. This is the question. And here they have deducted cess from the land acquisition. So, Your Lordship, in my understanding of this act, kindly see 23. Of the act, page 66, section 23.
Yes.
Here, the executive committee or concerned authority in its behalf may by public notification or by official order levy or collect, fix or control revenue, cess costs, charge payable by any landowner or passholder, and may prescribe the manner and period in which such revenue, cess costs, ban charges are to be paid and collected. Kindly see 2. In exercise of the power vested to it by section 1 of this section and subject to the provision of section 22 of this act. 22 is above 23. I'll read out 22, Your Lordship. Subject to the 22, section 22. No land survey, spot verification and measurement over any land allotted to any person by the district council in accordance with the Mara Autonomous District Council Non-Agricultural Land Settlement Act 2011 and the Mara Autonomous District Council Agricultural Land Settlement Act 2011 or any other law enforced in the district council area shall be carried out on by any person, governmental or non-governmental, department or agency for any purpose except by the district council. Number 2, in case any land is necessary for any purpose to be surveyed, verified and measured, the owner of the land in question, kindly notice that the owner of the land in question shall apply for the same in writing before the concerned authority under the district council, and the concerned authority shall perform such required work as and when it deems necessary and in the manner as it may deem appropriate. In certain case, the concerned authority may on its own initiative perform such needful work under this act, this section, as it may find necessary in presence or consultation with the landowner or otherwise. Lordship, in this, the instant case, this is land acquisition. We are not asked for the survey of my land. I have never submitted in writing asking for to survey my land. The acquiring authority asked for the acquiring my land, and notification was passed by the government, and the government initiated the process. So, Your Lordship, in my understanding, this law is for other survey, not land acquisition. Since land acquisition, we have another, administrative costs also you have paid. You already paid administrative costs. So in this case, I never asked for my survey of my land or verification. So in this case, you have to ask for.
Is there any head for administrative cost?
Yeah,
Anyway.
here they have a notification they have made, Annexure 6, and they have just said 10%.
No, in the Act, Land Revenue Act.
In this act, they have kindly see 23(2)(b. Here, to collect and levy cess to the extent of 15% or costs or charges, which may be increased or decreased and fixed by the executive committee from time to time by official order or notification from any landholder from the value of the land and on any other ground and in the manner as may be prescribed from time to time for the conduct of spot verification, survey and measurement or any other administrative work or other ways as provided and besides under subsection 1 of section 22 of this act on certain and special occasion as the case may be. And the next,
So,
Yeah.
there's a mention of administrative work.
yes,
So what you have paid is administrative charge.
Judge, yes. So in this case, Your Lordship, this is for,
So-
this act is not for the acquisition of land.
I've understood what you're trying to say,
Yes,
but you said you have paid administrative charge.
yes,
So provision perhaps which provides, which is
Yes.
provided in the Act is this administrative work,
yes,
chargeable for administrative work.
yes,
How much have you paid and how is it calculated? Any amount,
yes.
any criteria for calculating that?
Here in the acquisition, they have charges 2.5 of the from the total compensation. You have already paid
2.5?
of the total compensation.
2.5 what? Lakhs?
2.5% of the total compensation. This coming to 19 lakhs
2.5%
person.
towards administrative charge.
Yes,
Okay.
administrative cost. They
Okay.
mentioned. Yes.
But do they work out? Is there any workout for
Yeah,
that?
walkout is there. Kindly see page 55.
55
Yes,
of the writ petition.
of the writ petition. Got it, Your Lordship. Summary
Serial
of
number?
the award. Yes.
Serial number?
Serial number 8.
No, it just says 2%, 2.5%.
Yes. It comes to 19 lakhs.
No, what is the reason behind quantifying it as 2.5%?
I don't know, Your Lordship. They have not mentioned that.
But you have no issue with that, isn't it?
I have no issue. I already
You take
paid.
2.5%,
Yes.
but not the cess.
Yeah.
Okay.
You have already paid.
Okay, we'll, since Mr. Fakoma wants time, we'll have it
Yes.
tomorrow then.
Yes.
Court master, just come.
Lordship, no more adjournment.
No, I won't, madam.
I have difficulties also. I have.
Let's see, we will have it tomorrow. See, tomorrow we'll have a DB for a short while.
Yes.
Justice Kalita might leave tomorrow. So I'll be free. We can have this matter tomorrow.
I'm deeply
Mr.
obliged, Lordship.
Mr. Lal Fakomo, Learned Counsel for the respondent, MADC, submits that as he has some personal difficulties to make his submissions today. He prays that the matter be adjourned and be posted again after a day, posted tomorrow. Post of Ms. Dinari, Learned Counsel for the petitioners, I have no objection. In view of above, list the matter again tomorrow for admission. You are there, Ms. Lal Nundui? Ms. Lal Nundui, Learned Government Advocate, PS for the state respondents.
I'm deeply obliged.
Item number 5.
Your Lordship, this case has been endorsed to Miss Carolyn, and she's on foot in the other courtroom. So, Your Lordship, the matter may be passed over for.
Mr. Malhotra, have you filed your reply?
Yes, Judge. Notice is still incomplete, Judge. Service report is awaited. I filed my reply, Judge. I took steps on 15th of October. 15th of October.
And notice was sent through the
Registry.
registry through the post office on 21st of October. Today is 29.
We can await. Sorry.
Yes, yes. Mr. Malhotra has filed the reply affidavit.
Yes, my lord.
Now, private respondent number 4 is there,
Yes, my lord.
and notice was sent on 21st of October. There's no
Reply.
reply or acknowledgement till date. What is to be done?
Judge, we can wait for the reply. Since only
But, my lord, if the matter can be heard today, because there is an interim order.
That's why I was indicating notice is not complete. So should we go ahead or what to do?
yeah, my submission, Your Worship, is the notice may be awaited.
I have taken instructions from the respondent number 4, and he said that he will not be contesting.
Sorry?
The respondent number 4. He's saying that he will not be contesting.
You have information.
Yes, my lord, from the department.
Where is he otherwise?
He's still holding the same post.
Joint CEO.
Yes, joint CEO.
And the petitioner is?
Is chief informatics officer.
So, Mr. Malhotra, I think you can go ahead.
Your Worship, then if I may take a Lordship to page 19 of the writ petition.
Yes.
It appears from this that the respondents have transferred the petitioner to the post of Joint Secretary ICT.
Yes.
And by this impute notification dated 3rd of September 2024. And if I may take your lordship to paragraph 10 of the writ petition.
Paragraph
10 of the writ petition.
10.
Yes.
Yes.
Lordship, if I may read, respondents number 1 to 3 have not created any posts of secretary, joint secretary, deputy secretary, and under secretary in the Secretariat of ICT department, except the post of superintendent till date. In fact, all the existing incumbents officers, all the existing incumbent officers under ICT Secretariat are holding the post as dual charge. It is therefore truly inappropriate and illegal to transfer the petitioner from the post of Chief Informatics Officer to the post of Joint Secretary ICT Department, which has not been created. In other words, the petitioner was duly promoted by the respondents number 1 to 3 to the post of Chief Informatics Officer by following all procedures of law, and he cannot be ousted from the said post without following the procedure established by law in violation of the 2012 recruitment rules. So, Your Worship, it is a clear statement made by the petitioner that there is no post of joint secretary created by them. And with regard to this, these respondents in para 8 of the affidavit in opposition. In the affidavit at para 8, at page 4, bottom of the page, Your Honor, that with regard to the statements made in para number 10 of the writ petition, I say that there is no post of joint secretary created specifically for information communication technology department. So there's a clear admission on their part that there's no post of ICT joint secretary created by them. However, there are a number of joint secretary posts which were created without mentioning specific departments. Transfer and posting of employees and allotment of department are within administrative prerogative of the government. There is no misconduct or malafide in the impugned orders. However, there are a number of joint secretary posts which were created without mentioning specific departments. This is the stand taken by them. At the same time, admitting that no post of joint secretary ICT has been created. Now, they have not enclosed these orders creating the post of joint secretary without mentioning specific departments. This is just a bold statement, which I have denied in my affidavit in reply. If I may take a lordship to para 8 of my affidavit in reply.
Ms. Caroline, you take your seat.
Yes, sir.
I'll be hearing one counsel at a time. Yes. Para 8.
Of my affidavit in reply.
Yes.
If I may
Yes.
read from para 8. With regard to statement in para 8 of the affidavit in opposition, I beg to state that since the respondents 1 to 3 have admitted that no post of joint secretary ICT has been created, it is clear that the transfer of petitioner to the post of joint secretary ICT is illegal, as the petitioner cannot be transferred to a non-existent post. It is denied that the respondent 1 to 3 have created a number of joint secretary posts which were created without mentioning specific departments. In fact, a post cannot be created by the respondents 1 to 3 without mentioning specific department for which the post has been created. The fact that different posts are created for specific departments may be seen from the following notification orders. I have enclosed some orders and notifications which show that each post is created for a specific department. If I may take your lordship to annexure 1, for example, at page 9, at page 8.
Yes.
If your lordship will see page 8, this is order dated 28th of March 2008. In the interest of public service, the Governor of Mizoram is pleased to create one post of Joint Secretary, Police, in the Secretariat Home Department by upgrading one post of Additional Superintendent of Police, Prosecution, in the scale of pay of so and so. So, even in this case, the Joint Secretary post has been created in the Secretariat Home Department. It is not, it has to be against a specific department. It cannot be without any department, Your Worship. At page 9, if I may take Your Worship to page 9. This is also notification dated 17th of April 2008. In the interest of public service, the Governor of Mizoram pleased to order upgradation of the following 3 posts to higher posts in the scale of pay as shown against each for encadrement to the MSS cadre. Serial number 2, the Undersecretary post in the Political and Cabinet Affairs Department, if your lordship will see, has been upgraded to the post of Joint Secretary, Education Department. So it is against a specific department. It is not just without any department. Serial number 2, the post of Undersecretary, Political and Cabinet Department, having this pay scale, column number 4 has been upgraded to the post of Joint Secretary in the Education Department. So it has to be in a specific department. Again, at page 10. Notification dated 7th of November 2008. In pursuance of government notification number so-and-so dated 13th October 2008, the Governor of Mizoram pleased to declare upgradation of the following 3 posts to higher posts in the scale of pay as shown as against each for encadrement to the MCS, Mizoram Civil Service Cadre Post. Serial number 3, Deputy Secretary Corporation created by so-and-so has been upgraded to the post of Joint Secretary Corporation Department. Again, at page 11, Your Worship. In the interests of public service and in relaxation of ban on creation of posts, the Governor of Mizoram pleased to order creation of the following temporary posts under Vigilance Department in the Civil Secretariat. Serial number post, 1 post of Joint Secretary. So this has also been created for the Vigilance Department. So this statement made by them in their affidavit at para 8, that there are a number of Joint Secretary posts which were created without mentioning specific departments is totally false. And they have not enclosed even one order creating such posts. In their affidavit in position. At para 8, at page 5, second line. However, there are a number of Joint Secretary posts which were created without mentioning specific departments. Now, these orders creating these posts of Joint Secretary have not been enclosed by the respondents in their affidavit. But whatever documents we have been able to get hold of, Your Worship, all the posts are created against specific departments. And in the first part, they have admitted that no post of Joint Secretary ICT has been created. So how can the petitioner be transferred to a non-existent post? Where will he get his pay from? The order does not mention where he get his pay from also. Annexure 5, page 19 of the writ petition. And para 7 of the affidavit. filed by the state.
Yes.
If I may read para 7. That with regard to the statement made in para 9 of the writ petition, I say that eligibility criteria for promotion to Chief Informatics Officer, Informatics and Communication Technology is the Principal Information Officer with 5 years regular service in the grade. At present, there is no eligible officer for promotion to Chief Informatics Officer in the feeder post, that is Principal Informatics Officer. The petitioner is due to retire on 28th of February 2025. The feeder post will still be vacant upon his superannuation. As the senior most officer in the grade Senior Informatics Officer, namely Vangal Ringer, Senior Informatics Officer, Information and Communication Technology, is still ineligible for promotion to Principal Informatics Officer. Hence, transfer of respondent number 4 has been made for administrative exigency and in the interest of the public, as the department is unlikely to function without head of office. This is very interesting, Your Worship. They have admitted out here that there is no eligible officer who can be promoted to the post of Chief Informatics Officer as per the recruitment rules. And at present, I am the only person who is holding the post of Chief Informatics Officer as per the relevant recruitment rules. And they have admitted that even the senior most person in the feeder grade is not eligible. Then if that is the case, where is the sense in transferring me out? I'm the only eligible person as per the recruitment rules. And I'm due to retire on 28th of March 2025. But this transfer order has come out in September, in spite of the fact that there is no one eligible to replace me in the feeder grade. And I'm the only eligible person who has the technical knowledge to hold the post. So where is the logic in transferring me out? The rule says it's in the writ petition, Your Honor. Page 15 of the writ petition. Page 17, Your Honor.
Yes.
This is the post of Chief Informatics Officer. That is column number 1. Column number 11. Method of recruitment, whether by direct recruitment or by promotion or by deputation / transfer, and percentage of post to be filled up by various methods. So it is 100% by promotion. It does not talk about deputation, transfer, etc. Now, in case of recruitment by promotion / transfer / deputation, grades from which promotion, deputation, transfer is to be made. Promotion from Principal Informatics Officer with 5 years regular service in the grade. So now they are admitting that there is no eligible candidate in the feeder post of Principal Informatics Officer who has the necessary qualification of 5 years. And in spite of that, I have been transferred out. And the reason they're saying is that I have been transferred out for administrative exigency in their affidavit. When I'm the only qualified person holding the post, and the person in the feeder post has not fulfilled the eligibility criteria to be promoted. So what is the sense in transferring me out? This shows that there is some malafide in the process of transfer. Although they say the transfer is made for administrative exigency. What is the administrative exigency? I'm the only qualified person holding the post.
So this post of Chief Informatics Officer
Yes,
is 100% by way of promotion.
100%.
Who can be promoted? The Principal Informatics Officer with 5 years regular service in the grade. Now, as per the affidavit, there's nobody who has completed 5 years. But respondent number 4 has been brought in.
Yes.
in exigency of service.
They say. So when I'm holding the post, I've been promoted to the post. I'm the qualified person holding the post, and the person, the feeder post, has not fulfilled that necessary requirement of 5 years. Where's the administrative exigency in transferring me out at this stage when there's no one qualified to be promoted?
And you're retiring in February 25.
Yes.
Who will come in then?
Then you should, then when I retire in February 25, then the problem will come up. But now, before when the problem comes up, they have already shunted me out. So what is the actual reason? It is not because of administrative exigency. If it is due to administrative exigency, they will keep me there till my retirement. Because I'm the only person holding that post who has been promoted. So the reason for shunting me out, transferring me out, is not administrative exigency. Because it makes things worse for them. And since there's no post of Joint Secretary ICT, as admitted by them, how can I be transferred to a non-existent post? Nothing is mentioned regarding where I'll be getting my pay also from. Although they claim that there are some posts of Joint Secretary which have been created without naming the department concerned, but they have not produced those orders.
The orders which you have annexed in your reply affidavit are basically upgradation from at certain particular posts to the post of Joint Secretary.
They are also creation of orders, or the creation of, in fact, if your Lordship will see, page 8.
Yes, creation of post, but by way of upgradation.
No, Your Lordship, yes.
It is by way of upgradation.
Yeah, upgradation.
So that's why the pay scale and all are mentioned here.
But, Your Lordship,
But,
it has to be against a specific department. All these are against specific departments. And Your Lordship, page 11 is not upgradation. Page 11. Page 11 is a
Vigilance Department,
creation of posts in the
Joint Secretary and the Secretary Superintendent Assistant, and with the number of posts and then the pay scale of pay band being provided.
Governor of Missouri pleased to order creation of the following temple. So this is not an upgradation of posts, this is a creation of posts. In the affidavit at page 5, second line, they claim that they have created a number of Joint Secretary posts without mentioning specific departments. They have not produced even one.
So that's your case?
Yes, Your Honor. I mean, yes, now I'd just like to explain again that how can it be in the interest of administrative exigencies when I'm the only person eligible to hold the post? I've been promoted to that post and I'm the only qualified person. No one in the feeder post has the qualification of 5 years. But in spite of that, they have shunted me out. So what does it show? It is not in the interest of administrative exigency. There's something else behind that.
Right now, you are still there
I'm still there.
by virtue of the interim order.
Yes.
Any decision you want to rely upon?
No, Your Honor. Because they have admitted that there is no post of Joint Secretary ICT.
Transfer otherwise is an incident of service.
Yes,
Once you have given a job, you can be transferred anywhere.
that is there.
But what you are saying is that there has to be a post created for me to go.
Yes, I
So
cannot
that
be
from where I can draw my salary
Salary, yeah.
at post created. And if it's administrative exigency, it has to be shown also what is the administrative exigency. The rules also provide that it's 100% by way of promotion.
No
And
deputation.
they also
transfers
admit that there's nobody eligible as of now.
And and they also admit that there's no post of Joint Secretary ICT.
There's no provision for promotion by way of transfer, promotion by way of deputation.
And they also admit, Your Worship, that they have
This is
not,
the only rules. It has not been amended.
there's not been
2012 or 11.
12.
All right. Miss Caroline?
Yes, my lord. I would like to mention that the transfer of the petitioner to the post of Joint Secretary is not a non-existent post, my lord. It is not admitted that there is no post of Joint Secretary created specifically for ICT department. In fact, the government had followed the due procedure of law for post creation, my lord. And my lord, moreover, the petitioner is very much aware of the fact that Joint Secretary ICT is not a non-existent post. My lord, I have two notifications. I have just recently received from the department, if I may be allowed to put this for the court. Notification dated 12/6/2020 and notification dated 7/12/2020, which shows that the petitioner has been holding the post of Joint Secretary ICT even after he had been appointed as the Chief Informatics Officer ICT from the post of Principal Informatics Officer on 8/11/2012.
No, what is this? One by one. Notification 12 June.
Yes, my lord, 12 June 2020.
State Broadband Committee.
Yes, my lord.
Yes. How is it relevant to this
Because,
case?
my lord, here the petitioner himself has signed as a joint secretary to the government of Mizoram ICT. So it is clear that, my lord, this joint secretary post is not a non-existent post.
Department of Information and Communication Technology. What is this department? They have a directorate, ICT. It's a directorate. And at the government level,
Yes. Your Worship, like, if you also will see para 10 of the writ petition.
yes.
The respondents 1 to 3 have not created any posts of secretary, joint secretary, deputy secretary, under secretary in the secretariat of ICT department, except the post of superintendent till date. In fact, all existing incumbent officers under ICT secretariat are holding the post as dual charge. So there's no post created, but they're holding it as dual
All
charge.
existing incumbents officers under the ICT Secretariat.
Are holding the post as dual charge.
Dual charge, that means you are also holding the post of Joint Secretary, or what?
Yes, my lord, he was holding the
He
post
was,
of joint
not
secretary.
now. I'll have to get clarification on this, but
He
but
was,
as we have stated, they are holding dual charge against the post of, most probably against the post of the Chief Informatics Officer. He was holding the dual charge of Joint Secretary.
Joint Secretary.
But the fact remains that there's no post of Joint Secretary ICT. And now, as per the transfer order, he has been transferred to the post of Joint Secretary ICT. And there's no direction to hold the post of CIO and Joint
If you
Secretary.
are already holding the dual charge, where is the question of transfer?
No, he was, she said, not now.
By which order were you promoted to the Chief Informatics Officer?
order dated 8/11/2012.
Page 18. Page 18, Your Honor, of the written.
Page 18.
He was promoted on 20th of November 2012.
Principal Informatics Officer.
I was holding the post of Principal Informatics Officer, then I was promoted to Chief Informatics Officer.
Now, is there a separate rules for that Chief Informatics Officer?
Well, we just read that. Page 15.
No, this is for Chief Informatics.
Yes, yes, this is, and this page 18,
What about Principal Informatics?
there'll be a separate RR.
It's not available in the writ petition?
No.
Now, why specifically for only chief there's a separate thing? It could have been both together because the principal chief informatics officer is the feeder post.
They have separate RR for Principal Informatics Officer also.
It appears so, but the thing is that since the principal informatics officer is the feeder post to be promoted to the chief informatics officer, it ought to have been under one RR.
One RR.
And what about the other letter or notification you produced?
That is also similar, my lord.
Okay, similar.
Yes.
This is to show that he signed as a joint secretary.
Yes, my lord.
And he was all along joint secretary earlier also.
Yes, my lord. So it is not a non-existent post.
Yeah, he was holding dual
So,
charge.
when did he come back from joint secretary to the chief informatic officers?
That I could not get hold from the department, my lord, because he is the chief informatics officer and he's not giving any other.
This is interesting.
This is very interesting. If your lordship will give me some time to get instructions. If he was already holding the post of joint secretary, where is the need to transfer him to that post? Or
It's the.
I will come back at 2.
Yes,
Meantime, you speak to your respective clients. We'll see what can be done.
if he's already holding the post of joint secretary,
But my lord,
where
he
is the
himself
question
had
of transferring
created this
him?
chief informatics officer recruitment rules. He was also.
Try to get the rule also that
Yes, my lord.
principal informatics officer, if there's a recruitment rule, produce that.
Yes, my lord.
Let us see what kind of ICT thing is this. Because ICT is an important thing
Yes, my lord.
and a new concept.
In fact, my lord.
It's very
this-
relevant in recent times.
Yes, my lord.
So, probably
It's very important, Your Worship, but they are insisting on transferring me out. Although I'm the only qualified person.
right. We'll come back at 2.
No,
This is also promotion 100%. Principal Informatics Officer. From Senior System Analyst, 5 years. Everyone has got the individual separate recruitment rules.
every. Your Lordship, my learned colleague has pointed out that she had produced some documents where the petitioner has signed as
Joint Secretary.
Joint Secretary. Your Lordship, I just rang him up. He said he was given ex officio charge in addition to his appointment, promotion as chief CIO.
So where's the document?
I need some time. I mean. He was given ex officio charge, and that was only till about last year. Because my learned friend has produced. It's all on me. It's on me. Your Lordship, my learned friend has produced a document dated, notification dated 28 December 23.
Yes. What is that?
It shows in this notification, my lord, it shows that the post of Joint Secretary ICT is not a non-existent post. At serial number 2.
She is holding dual charge, CNI/ICT.
Who?
Serial number 2, Pinky Zosampi,
CNI means?
Commerce and Industry.
Okay.
So she's that is the stand throughout. They're holding dual posts. In fact, Your Lordship, in their affidavit, they have admitted there's no post of Joint Secretary ICT. So even this notification shows that serial number 2 is holding dual charge.
No, there's no issue. Dual charge can be there.
Yes, my lord.
A secretary of a department can be a secretary of another department, like that, vice versa, in respect of additional joint secretary, under secretary, or deputy secretary.
But in this case, the petitioner, if Your Lordship will see the impugned transfer order, he has been transferred to a non-existent post, page 19 of the writ petition. He's not holding, if Your Lordship will see it, notification dated 3/9/24.
So, if you were holding the charge as ex officio, in addition to being the principal chief informatics officer, at the relevant time.
At the relevant, I was getting my pay from the post of CIO.
At the relevant time when you were having that dual charge, or as ex officio, you were the chief or you were the principal? Chief.
So I signed these documents as the Joint Secretary CIO because I was holding the dual charge in 2020.
But if there's no post, where is the question of there being a dual charge?
No, but Your Lordship will see even this lady, serial number 2, she was given dual charge.
But it is not a case that there is no post of Joint Secretary CNI or Joint Secretary ICT.
There's no post of Joint Secretary ICT. That is admitted by them in the affidavit.
We have
Since
not
we were holding
admitted
dual
to
charge,
that, my
that
lord.
is why. I was given additional charge. If Your Lordship will kindly see the affidavit filed by them. Para 8. With regard to statement made in para 10 of the writ, I say that there is no post of Joint Secretary created specifically for ICT.
So let Ms. Caroline get instructions then. On the question that how do you post a person in a non-existent post, and from which head will he get the salary? Clarify that.
Yes, my lord.
And in the meantime, if you want to bring that, what do you call that,
Ex officio.
ex officio in charge, you can file.
Yes.
Please write. Parties are represented by the respective counsels except for respondent number 4. Stop notice was sent to respondent number 4 on 21/10/2024, but neither AD card nor unserved notice has returned back. Stop. Ms. Caroline Kelung Oipui, learned government advocate, submits that as per the information received by her, the respondent number 4 will not be contesting the case. Next para. Referring to the impugned transfer order dated
3-9.
3/9/2024, bracket, annexure 5, comma, Mr. A.R. Malhotra, learned counsel for the petitioner, submits that the petitioner has been transferred to a non-existent post. Stop. The same has clearly been admitted by the state respondents in their counter affidavit at paragraph number 8. Stop. It is also, no, stop. This apart, there is no indication in the impugned transfer order as to the source for drawing of salary by the petitioner. Stop. Next para. Considering the above position, full stop. Okay. Considering the above position, you can cancel that. Next para. The learned government advocate also submits that the petitioner was in fact holding the post of Joint Secretary, ICT, in the year 2020. Stop. Mr. A.R. Malhotra, learned counsel for the petitioner, however, submits that the same was
On ex officio basis.
on ex officio basis only. Next para. In view of above, the learned government advocate shall obtain instructions as to whether the petitioner can be posted against a non-existent post. Stop. Secondly, even if the same is possible, what would be the source of drawing the salary by the posted officer? By the not posted officer, by the transferee. By the transferee. Full stop. Next para. List the matter again. When?
After 2 weeks. Your can keep it part heard also.
Is it required? Can be sorted out by anyone.
On 12th of November, if it's possible, my lord.
When?
12th of November.
List again.
Your may kindly fix at 18th. But then I think your will be back. Since your lordship is already aware of the fact. Your may 18th or 19th.
What do you say?
It's up to your lordship.
Well, that's a long time actually. You were in a hurry actually, no? Because of the interim order. But unless we come to know about this situation, then it's difficult to take a decision.
By Lordship, I think by week commencing 18, Lordship will come back.
Okay, list the matter again on 18th of November 2024. The learned government advocate will obtain appropriate instructions by then, and the petitioner may file an additional affidavit incorporating the order by which he has been posted as Joint Secretary ICT on stopgap basis,
Or ex officio.
on ex officio basis,
Lordship, interim may kindly continue.
till the next date. Interim order passed earlier shall continue.
I move.
Item number 8 for hearing.
Yes. What is this matter?
Also, this is a make appeal. Lots of the brief facts of the case is that on 17 February 2013, the deceased Lalnun Lima, while preparing a bitumen by using fire in the extreme corner of the road, a truck bearing registration number MZ070349, driven by the respondent number 1, owned by the respondent number 2, ran over the firewoods, and as a result of that, the bitumen spilled over the body of the deceased, Your Lordship. And on his way to the Long Ply Civil Hospital, he succumbed to his injury. Then
What is the date?
date is 17/02/2013. 17/02/2013.
Who are the appellants?
Appellants, there are 4 appellants. Appellants number 1 is the mother of the deceased, and the others are 2 minor daughters and 1 son.
2 is the son
Son, Lordship, yes.
and 3 is the daughter.
Daughters.
Minor at the relevant time or even till today?
Lordship. At that relevant time, Lordship.
Okay. Now the deceased expired on the same day.
On the same day, on his way
17
to, yes, on his way to Long Ply Civil Hospital.
From?
he succumbed from the place of accident.
Where is that?
Lordship, this place is that Boong Klang South, which is they are just burning a bitumen in the extreme corner of the road for the repairing of the road, Your Lordship.
Boong Klang South.
Boong Klang South.
And then on the way to Long Klai.
Yes, Your Lordship.
Okay, and was he an employee of the
Yes, Your Lordship.
PWD?
Yes, Lordship, during his that relevant time, he was a casual paid labor under 71 RCC 24 BRTF Project Puspa.
Casual paid labor.
Casual paid labor, Lordship, which is at page 8, Exhibit C.
Under?
Under 71 RCC /24 BRTF /Project Puspa.
So the mother and the minor children made a claim
Yes, Your Lordship.
and that was dismissed.
Yes, Your Lordship.
And who's the respondent now?
Respondents number 1 is the
Driver.
driver, and number 2 is the owner of the accident vehicle.
What is that vehicle? Truck.
Truck, yes, Your Lordship.
What kind of truck is that?
It's a truck. This is which is at page 18, Your Lordship.
Where's the judgment? Judgment starts from which date? Which page?
Judgment
Starts
in
from
word is at page 72.
72.
72, Lordship, yes.
MZ07.
MZ07. Lordship. The registration certificate is at page 18 of the paper book.
Registration is okay?
Registration is okay, Lordship.
It was insured, not insured.
Not insured
That's why
at
the
that
one has
relevant
come.
time. Yes, Lordship.
Why was it dismissed?
Lordship, the Learned Tribunal had framed 3 issues, and the issue number 1 was regarding the maintainability. It was decided in favor of the claimant, and this issue number 2 is regarding fault, and 3 is regarding the negligence. And the Learned Tribunal found that there is no, the claimants did not prove their case regarding that negligence.
Regarding negligence.
Negligence, Lordship.
Where was the bitumen being, what do you call that? Bitumen?
Bitumen, yes, Lordship. For this purpose of this road construction.
For repairing the road or for constructing the road, that bitumen was being heated up.
Heated up, yes, Lordship.
It was in the middle of the road, heated
No,
up.
it
On the
extreme
side
corner of the road, in the
Okay.
side drain.
Okay.
Usually that Your Lordship knows that in the side drain they're heating up. Your Lordship.
But the tribunal said that they failed to prove the
Failed to
negligence.
prove, Your Lordship. Then we produced 2 police personnel who had inquired the matters at the spot also, Your Lordship.
Any inquiry report?
Police report is there, Your Lordship.
Okay. What does it say?
The police report is at
Is in your favor or against you? Against you.
It's in my favor, Your Lordship.
Okay.
Then the police personnel also called before the tribunal.
The truck went on the side of the road and drove over the bitumen.
Drove over the bitumen, ran over the firewoods. Firewoods, yes, Your Lordship.
And the bitumen got spilled.
Spilled.
And it spilled over the deceased.
Deceased, Your Lordship.
Okay.
Then he ran ahead from the spot of the incident and did not stop.
Okay. So what is your prayer? That it should be remanded back? Or what?
Lordship, yes, my prayer at this stage is let the case be remanded back to the Learned Tribunal to reconsider the case. Because, Your Lordship, the Learned Tribunal failed to appreciate the evidence adduced by the witnesses.
How many witnesses?
We have as many as 3 witnesses. And the witness number 1 is the claimant, mother of the deceased.
3.
3
witnesses.
As many as 3 witnesses.
Mother.
And number 2 is the person who prepared the police report. And the third one is Esailal Kumsanga, is the officer in charge and who is the inquiry officer in this case.
And the defense? Opposite party?
Opposite party had contested by filing their WS, both of them, and both of them came before the Learned Tribunal to adduce evidence.
Opposite party means both the driver and the owner?
Yes, Your Lordship. And they rely upon the judgment and order passed by the Learned CJM Longklai in the criminal case number 15 of 2013, wherein the driver was acquitted on the ground that the prosecution failed to prove their case beyond doubt.
What is the case number?
15 of 2013.
What 15?
Criminal trial number 15 of 2013.
Driver was acquitted.
Acquitted, Lordship.
By order dated?
Order dated 13 to 2014. 13 to 2014.
So that order was relied upon by the tribunal?
Lordship.
Tribunal order is dated?
Tribunal order is 70.
Judgment and award.
Yeah, judgment and award. So page 72. 2/12/2021.
So, did the tribunal rely upon the criminal trial judgment?
Lordship, it has discussed, but saying that not exactly relying upon the criminal judgment, but it has been discussed. at length, Your Lordship.
So what is your ground of appeal?
Lordship, yes. My grounds of appeal is at page 126, Your Lordship. Grounds number 2, Your Lordship. For the learned tribunal failed to appreciate the evidence adduced by the witnesses before the tribunal. In fact, the learned tribunal stated in the impugned judgment award dated such and such that the fatal accident occurred through a series of unfortunate events. However, it is pertinent to mention here that as per the investigation done by the police and the cross-examination of the respondent, opposite party number 2, in his admission, admitted that the vehicle truck had run over the firewood, which in turn toppled the boiling bitumen, causing serious injury, which subsequently led to the demise of Lal Nunlima. Moreover, the fact remained was that the deceased died arising out of the use of motor vehicle. Had the said vehicle did not run over the firewood, the boiling bitumen could not be turned toppled to cause death of Sri Lal Nunlima. Number 3, for the learned tribunal rejected the claim application on the ground that the claimant failed to prove the requisite negligence even on the test of preponderance of probabilities, and that the claim under section 166 of the MV Act 1988 failed in the instant case. However, the findings of the learned tribunal are contrary to the evidence on record. The claimant's witnesses deposed that the accident occurred due to rash and negligent driving on the vehicle truck. The concerned police had registered case under Longklai PS case number such and such under 279 to 325 427. In order to prove rash driving on the part of the driver of the accident vehicle, the claimant produced two police personnel, including inquiry officer, and both of them had visited the place of occurrence and found that there was rash and negligence on the part of the driver. On the other hand, no evidence had led by the respondents to rebut the evidence led by the appellant. The examination in chief and deposition adduced by the police officers against the driver of the vehicle also supported the appellant's case. Number 4, for the learned case, for the case IO, namely SI George L.H. Zava, had clearly stated before the learned CJM Longklai, District Longklai, as prosecution witness number 9 at para 14 of the judgment and order, and such, being the case IO, he opined that the vehicle driven by the accused driver of the accident vehicle remained run ahead even after the incident. There was negligent act on the part of the driver. Moreover, the case IO stated that his charge sheet was mainly based on the report of the inquiry officer, although he visited the place of occurrence. In this regard, though the case IO, namely SI George L.H. Zava, did not depose evidence before the learned tribunal at Aizol, however, the inquiry officer, namely SI Lalkum Sanga, was summoned and deposed evidence before the learned tribunal, wherein he had clearly stated that the accident occurred due to rash and negligent driving of the driver of the accident vehicle, and his stance did not shake at the time of his cross-examination.
Okay, how many IO?
Also, case IO
One is
only
George.
one. Yes,
One is Lalkum
Lalkum
Sang.
Sanga is the one who had done the inquiry.
Then George.
George is the case IO who submitted the charge sheet before the learned CJM.
So what is the difference between them?
Also, this inquiry is usually done at the when they have received the a report, then the inquiry officer had visited the place of occurrence immediately.
Who was that? George.
No, that's SI Lalkum Sanga.
Lalkum Sanga.
Lordship, yes. He has been called before the learned tribunal to adduce evidence. He has came.
Then why George has come in again when he has gone to the spot to examine?
Lordship, this is the stance taken by the these respondents, saying that the case IO was not called before the evidence for the learned
No,
tribunal.
that is why when police report was made, SI Lalkum Sanga went to the spot.
No, Lordship, at the time when this accident was occurred, SI George L.H. Zava and Lalkum Sanga went together
To
the spot. Yes, Lordship. Because SI Lalkum Sanga is the officer in charge of the Boong Klang South police station.
Okay. And who's the IO?
IO
Inquiry
is
officer.
George L.H. Zava.
He's the inquiry officer.
He's not inquiry officer. Inquiry officer is SI Lalkum Sanga, Lordship. It's a big miss. Yeah.
Both of them are inquiry officer. Case IO and inquiry officer are the same. Any difference between them? On receiving information, SI Lal Kumsanga went to the spot.
Yes.
And also George also went.
Yes. Both of them are at the Bungklang police outpost.
Okay. Who prepared the report?
Report is prepared by, let's see, LP Zo Mangaya.
Different person.
Different person.
Who is he?
With the, because at the time when the FIR was filed, because both of them are already transferred, so he prepared the police report.
Okay. Then SI Lal Kumsanga deposed before the tribunal.
Yes, Your Lordship. And this LP Zomangaya also, the one who prepared the police report.
Prepared the report.
Lordship, yes. And both of them said that as per their observation inquiry, as per their investigation, rash and negligent driving was on the part of the driver.
Now, what is the role of SI George?
SI George, Lordship, this as per this respondents, the inquiry, he's the investigating officer. He was not called before the learned tribunal. That's why they did not prove their case. This is the stance taken by them. But for us, this inquiry officer was called before the tribunal and he had deposed. And even that, Your Lordship, this case IO had stated before the CJM that his charge sheet was mainly based on the report of the inquiry officer.
Okay, so grounds you have taken are mainly, see, as per the investigation done by the police.
Yes, Lordship.
And cross-examination of the respondent.
Yes, Lordship.
There was negligence. And the investigating officer, one of the inquiry officer, SLR Kumsanga, and the
Yes.
one who made the report,
Yes,
they were
Lordship.
examined.
Yes, Lordship.
So from their deposition, it can be said that there was rash and negligence.
Very true, Lordship.
So the tribunal's finding is not correct.
Yes, Lordship.
Let us come to the tribunal's order. Where is that discussion?
Discussion is Lordship, we start from page 93. It's very lengthy judgment, Lordship. This is the findings of issues number 2. Page 93 of the paper.
92,
93.
93.
Yes. Finding on issue number 2.
Where's the relevant part? Some of the pages, some of the lines are not readable.
Yes, and this page, one page is also missing, but it's not very much important, Your Lordship, in the judgment. I have
The LCR is called? There are 4 photographs in the claim petition,
4 photographs, Your Lordship.
but you have named only 3 appellants.
No, Your Lordship, 4 appellants.
4 appellants.
4 appellants, Your Lordship, yes.
But you said one is mother, 2 is the son, 3 is the daughter.
Lordship,
Then who's the 4th?
2 daughters, Your Lordship.
Okay, 2 daughters.
2 daughters.
But where is the judgment? Oh, it's here.
The relevant is from Your Lordship, paragraph number 22 of the judgment and word. Findings of the learned tribunal.
It's the same thing. From page 22, it jumps to page 24.
Yes, Lordship.
That 23 is not there.
Uh,
Paragraph 13 is not there.
But here in my that folio, it's there. It's available, Your Lordship. Paragraph 13 is regarding the police report. It was reproduced.
In your folio, it's there. Why didn't you annex it?
Lordship, I have annexed in my this appeal petition.
This paperwork is prepared by the registry.
Registry, Lordship, yes. In my appeal petition, page number A20, A19 and A20 in the beginning, Lordship. Lordship, yes.
Please read.
The second issue is whether there was any fault on the part of the driver or owner of the accident vehicle.
Wait just a minute. What is the first issue?
The first issue is regarding a maintainability. Lordship.
Whether it's maintainable or not.
Yes, Lordship.
Court said, tribunal said it's maintainable.
Maintainable, Lordship,
Okay.
yes.
The claimant deposed.
The claimant deposed that on 17/02/2013, Arson Lalnundima was preparing bitumen by using Fire 1 vehicle truck bearing registration numbers and such, driven by Lal Chungdunga, owned by Lal Thangmuana, allegedly ran over a firewood which was burned to boil the bitumen. As a result, the heated bitumen spilled on the deceased Lal Nundima body and he was seriously burned by the bitumen on his whole body, and he died due to his injury on the way to Longklai Civil Hospital. The driver did not stop the vehicle after the incident. On cross-examination, she stated her son allegedly met with an accident at about 4 p.m. at Bungklang South, that her son along with Lal Du Sanga were on duty on 17/02/2013 and were boiling bitumen on the left side of the road using the side drain as a fireplace, and that the distance between the side drain and the metal road was about 3 feet, and it was a curved road which was wide. The accident vehicle was proceeding towards Longklai from Vasaikai village. She was told by Lal Dusanga that the accident vehicle ran over the firewood used for boiling the bitumen, which caused the boiling pan plate to overturn, causing severe burn to the body of her son. In her cross-examination, she admitted the suggestion that her son had met with an accident on 17/02/2013, whereas the police report of the accident was prepared on 12/05/2015. The claimant witness stated that he prepared the police report dated such and such. The police report was exhibited. The same may be reproduced as under. A written FIR received from S. Parmoi, wife of such and such of Bungklang South, which is forwarded by officer in charge Bungklang South as outpost, stating that on 17/02/2013 at 4 p.m. his son Lalnundima, 26, son of such and such, working as a laborer in BRTF, and while preparing a bitumen by using fire to be hot, one truck driven by Chungdunga bearing registration number such and such has run over the bitumen, and in consequences the bitumen has burned down his arms and sustained serious injury on his body. Hence, she requested to take necessary legal action. Hence, Longklai PS case number such and such under section 279 325.427 IPC has been registered. He stated that the report was prepared on the basis of the investigation report prepared by SI George L.H. Zawa, which stated that the cause of accident was purely negligence on the part of the driver. However, he stated in the cross-examination that he was posted at Lunglei at the time of the accident. He was posted at Longklai sometime in October 2014. He visited the place of occurrence after his posting at Longklai, that is more than 1.5 years after the accident, and he did not find any physical remains of the accident. The investigation report relied upon by him was not annexed in the case record. As per the investigation report, the truck had hit the boiling bitumen, which overturned and burned the deceased in the process. He did not know the distance between the road and the place where the bitumen was boiled.
Just a minute. Who is this?
He's the
He
one
means-
who prepared the police report.
What is his name?
LP Zohmangaya, yes.
L.
LP Zohmangaya.
Where is his name?
His name is, yes, Lordship. His
Name
name
is not there.
is not there. It just simply started that he stated that. But his deposition is there, Lordship.
He is the one who prepared the police report.
Yes, Lordship.
So court is narrating the police report.
Yes.
So what? Where's the police report? Just see.
Police report is,
It's available in your appeal memo.
yes, it's there.
Page
Lordship.
number.
Police report.
Page number.
Page 14, Lordship.
40. Page
14, 14, Lordship.
in your appeal memo.
In my appeal memo.
Zohmangaya.
Zohmangaya. LP Zohmangaya.
Has run over the bitumen and in consequence the bitumen has burned down his what?
Arms.
Arms
Yes.
and sustained serious injury on his body. Hence the request to take necessary legal action. Hence long clarification.
279, there's a prima facie, is negligent driving. Lordship.
That was just registered, but what conclusion does it make, the report? Has it come to any finding? As per my visit to the spot or as per my finding on inquiry, I find that it was sheerly due to negligence of so-and-so.
Lordship, it's in
That
his
is not there.
deposition, Lordship, this the judgment and some of the deposition was not reproducing the judgment in Lordship. Some of them are pick and choose.
No, just see the police report. It's only one page, one
Yes,
paragraph.
Lordship, yes.
It's neither here nor nothing, neither here nor there. It just says that this is the report I received and this is what we have. This is the case. The case was registered. It does not implicate anybody. That it was in view of the negligence driving of the driver that the accident happened. Something like that. Nothing is there.
It's very, very casually, Lordship, that is.
So if it's not there, then how do you prove your case?
Lordship, he has been produced before the learned tribunal. He and
But
the
can
inquiry
he?
person.
But can he say something which is beyond what he had written?
That, Lordship, the case was registered under 279.
Police will immediately register 302.
Understand.
Does it mean that the person has been caught and he is guilty of this 302? Depending on the nature of the allegation, they registered the case. In this case, they said 279. What is 279 is what? rash and negligence.
No, Lordship, 279 is, yes, 279 is rash driving, Lordship. And 325 is voluntary causing grievous hurt.
So depending on the type of the allegation, police will register the case. Thereafter, investigation will go on. Then ultimately the charge sheet will be, police report will be prepared.
Yes.
Police report will indicate prima facie, I find that this person is guilty of 279. Where is that report? Which in turn can be support your case. Just because one case is registered doesn't say that the person, those driver was negligent. Six months, fine of rupees 1,000, both. Where is his deposition?
Deposition,
Zomaya.
Lordship, may take Lordship to the paper book, Lordship.
Paper book.
Paper
Page-
book, yes.
Page number.
Page number, page number 55.
SI George, based on the investigation report submitted by SI George LH Zava, the case of accident, the cause of accident was purely negligence on the part of the driver.
And the next is,
George was not produced before the tribunal.
George was not produced, Lordship.
Then I had visited the place of accident after the said incident, and I find that the deceased had prepared the bitumen on the corner of the road, and as such, I can safely say that there was negligence on the part of the. So where is his report that he visited the place?
Also, that is not there, Lordship.
Then-
Only the police report was prepared by him. And his knowledge is also after 1 year, Lordship, after 1 year of the said incident. And Lordship, another SIL Kumsanga was called before the learned tribunal, which is at page 58,
Accident happened on
17/2/2013.
17/13, and this police report is signed on which date?
Police report is on
2015.
2015, Lordship,
How? After 2 years.
after years.
Why?
Lordship, that
When was the FIR filed?
FIR was
After 2 years. Is it exhibited?
exhibited, Lordship, yes. No, FIR is not in the claim form and in the as well as in the paper book, Lordship. It seems that it was in the oral. A written FIR, yes, written FIR was there, but the FIR was not annexed here.
What is the date?
Date of this police report is 12.
No, FIR.
FIR date is also not mentioned, Lordship, in the police report.
Accident happened on 17/2/2013.
Lordship, yes.
After almost 2 years, police report is prepared. 15/2/2015. And what does the police report say? It says that this was the complaint received, we registered a case. That much only. So where is the negligence then?
Lordship, the one who prepared the police report and the inquiry officer deposed before the learned tribunal that they have visited the place of accident and they have inquired. And as per their inquiry, negligence was found against the driver of the accident vehicle.
When did they visit the place of?
Also, the SIL Kumsanga visited, it's there, which is at page 50.
The judgment you just read at A21 says, he visited the place of occurrence after he was posting at Longklai. That is more than 1.5 years.
Lordship, that was the one who prepared the police report, and the inquiry officer is at his deposition at page 58. May I take a Lordship to page 58?
Of the paper book.
Yes, of the paper book.
Who is this?
This Lalkum Sanga.
Yes, what is he?
He's the officer in charge and as well as the one who had done the inquiry.
So where is this inquiry report?
Inquiry report is not here, Lordship.
Then?
Then he had deposed before.
He may come and say anything he likes after 2-3 years. What is the value of that? See, accident happened.
Understand, Lordship.
Somebody died. FIR was filed. We don't know when it was filed. Normally, it should be filed immediately. After FIR is filed, they register a case. Person goes and does the investigation. Then he prepares the investigation report. Now, this is what I found. And whether that person who was found to be negligent was prosecuted or not, it's a different matter. This is a claim. So for the purpose of claim under 166, you are supposed to establish that there was negligence. So those documents will be relevant. Instead of just calling somebody and he will say that I went there and all that, but there is nothing recorded. He had gone there and found that this has happened. If those documents are not exhibited, what would be the value of his statements? He may add something more, more masala. He may put some more spice. We don't know what has happened. At least something should be there in writing at the relevant time.
Yes.
Then he can come and confirm, yes, I prepared this report because I went there myself on the visit the spot and this is what I prepared.
Very true.
Then that would be reliable for you. If that is not there, how can you just say that I had gone there, I know from my knowledge is wrong, he was negligent in driving, road was very wide, the bitumen was being boiled in the right corner of the thing, still the vehicle came and drove over the firewood, something like that. So how do you intend to prove your case if you don't have that?
Lordship, yeah, understand.
Lalkum Sanga.
Lalkum Sanga. Lordship, allow me to read
Yes.
paragraph number 4 of his examination in chief
Yes.
of this page 58, Lordship. At the time of the accident, I was posted at Boong Klang South Police Outpost as an in charge and I had visited the PO soon after the said incident. During inquiry, I found that the deceased along with his friend had prepared a bitumen by using fire at the extreme corner of the road. From my investigation, the driver of the truck had run over the firewood which was burned to put the bitumen, and as a result, the deceased Lal Nun Lima was burned down by the said bitumen. Therefore, it is crystal clear from my investigation that the cause of accident is rash negligent driving on the part of the vehicle, such and such, and the cause of death of Lal Nun Lima was due to burn injury to his body, which was caused by running over of the firewood used to burn the bitumen by truck registration number such and such, driven by Lal Chungdunga, which is owned by Lal Thangmuana. As a cross-examination is on the next page. I was posted at Boong Klang South in February 2012 till September 2018. It is a fact that I was posted at Boong Klang South Outpost during 17 to 2013 when the accident took place. It is a fact that the accident took place at 8:30 p.m. and I am sure that it was at night. The accident was reported verbally to the Boong Klang South outpost on the same night and GD entry was made and immediate action was taken by visiting the place of occurrence, but the victim and the vehicle were not at the spot of the accident. On the investigation, it is found that the road where the accident took place was very wide. It was just before reaching the curved corner. The bitumen was boiled at about 2 meters from the road and the road was 12 meters in width. The bitumen was boiled by the deceased and his friend in a bitumen barrel which vertically sliced into half. I do not know the weight of the bitumen plate along with the bitumen which was being boiled. As per my investigation, the bitumen was boiled by firewood. There was a single firewood which was horizontally placed in the fireplace which was run over by the truck bearing registration numbers and such, resulting to overturning the bitumen plate barrel and thereby causing burn injuries to the deceased Lal Nunlima. It is a fact that the deceased and the vehicle bearing registration number such and such did not have any contact with each other. I was informed by a friend of the deceased that the vehicle was driven at a high speed and that running over the firewood amounts to rash and negligent driving on the part of the driver, in my opinion. It is a fact that I do not know the outcome of the criminal case registered against the driver. It is a fact that even though SI George L.H. Zava was the investigation officer into the accident, I was in charge of Boong Klang South outpost. As such, I had visited the PO and entered CD, which was forwarded to Long Klai PS. I agree that only the police report dated prepared by Inspector L.P. Zo Mangaya is in the instant case record. It is not a fact that I am deposing falsely.
So, except for the police report
CBS.
prepared by this LP Mangaya, there is nothing. Investigation, you say investigation, he says inquiry, and some entry made in the CD. Where are those?
CD entry is not called, Your Lordship. That was not there.
Says SI George was the investigating officer.
Lordship, yes.
Why didn't you examine him?
Lordship, may I take Lordship to...
What is his finding?
Yes, Lordship. May I take Lordship to the page 29 of the paper book. It's a judgment and order passed by the learned CJM. 29, Lordship. The relevant is page 30. Page 30, brief accounts of evidence. In that paragraph number 5, serial number 9 is the George L.H. Zava, with the PW number 9, with the investigating officer. Lordship, his deposition is at page 31, paragraph number 14.
Yes, I've read it.
Lordship, yes.
But this is in the criminal case.
Yeah, criminal case, Lordship. Then he had narrated something, Lordship.
You should have brought him to the tribunal.
Lordship, that this has been submitted by the respondents in there.
Where is the report? The final report of the police?
Final report.
You do not exhibit that.
It's not there, Lordship. Yes, it's not
If
in our
it's not
person.
there, how do you intend to prove your case? This is the problem. Somebody died. You are just to show that it was due to negligence. And to show that negligence, you have made one report to the police through a fire. Police says that yes, we visited the spot. So there must be some record wherein it is written that we visited the spot. The road was this wide. Bitumen was on the corner of the road. Vehicle went to the corner of the road and ran over the firewood, causing the death of this person.
Lordship, yes.
So it appears that there was rash and negligence on the part of the driver. That report
Lordship, yes.
should have been exhibited and should have been, the author of that report should have been examined. Then you have a case. Without that, how do you build up your case?
That's that's it. Yeah, that this honorable court may remand it back to the tribunal. And regarding there is a one eyewitness that was inadvertently not
No.
called before the learned tribunal.
Just because you're asking for remand, the court will not remand it unless we find a reasons
Yes,
for
yes.
remanding it.
Understand,
You
Lordship.
must understand that. So that is why I'm asking you,
Lots
where
of
is that evidence to show that this was a case of rash and negligent driving supported by these documents or this
Understand,
evidence?
Lordship. Yes.
If that is there and if the tribunal had failed to consider that, definitely it calls for remand. But if there's nothing, what is there to remand?
Also, may I take Lordship to page 31. The statement of the case IO is SI George L. Zawa, paragraph number 14, Lordship.
I have read it. You
Oh,
want to read?
yes.
Read.
So the PW number 9 in his examination in chief mainly affirmed the charge sheet, being the case IO also opined that the vehicle driven by the accused remained run ahead even after incident. There was a rash negligence on the part of the accused. In his cross-examination, he admitted that the driving license and vehicle documents were valid. His charge sheet was mainly based on the report of the inquiry officer, although he visited the place of occurrence. So his charge sheet was mainly based on the inquiry officer. The inquiry officer was the Esailal Kumsanga, and he deposed before the learned tribunal, stating that the cause of accident was rash negligent. So
You're talking about this PW9.
PW9, Lordship. Who is the case IO in this accident case, Lordship?
Correct. You did not produce him as a witness. You have not even exhibited what he had prepared. Did you exhibit
That he has not called for
the
it,
final
Lordship.
report? This case was disposed of on 13 February 2014.
Lordship, yes.
And your MSCT claim was filed in the year 2022. No,
2018.
2018.
Lordship, yes.
And was disposed of only on 2/12/2021, much later than the criminal trial judgment. So you could have collected all the materials and presented your case before the tribunal.
And also regarding this non-examination of the best witness, who is the case IO, I have some authority, Lordship.
An examination of?
This they called it best witnesses. That the case IO, George L. Zava.
But you have not produced anything also. Supposing it's not fatal, not examining George is not fatal.
Yes, yes.
But what did George write?
That I have not.
that you
I
have
have
not
not annexed.
produced.
Yes, Mr. Lordship, I have not annexed.
That you
But
have
I
not exhibited.
not exhibited, Lordship.
So how do you build up your story? You file one claim in the tribunal and you'll call Mr. XYZ and come and say verbally, you tell the court that he's at fault. Will that be sufficient?
Lordship,
There has to be some process. Because you had said that you had made a FIR, you had invited the police, you had reported the matter to the police who went to the spot and verified about the accident. They have to record something and the GD entry has to be there. Police report is there, which is prepared after almost 2 years. And if the police had indeed gone there and made the investigation, you should have exhibited that. This is the finding of the police. Because the police report which you have just annexed here, it only speaks about registration of a case. That's all. It does not say that this person was at fault or that person was at fault. So nothing can be derived from this police report. Except that something happened that day. That's all.
And Lordship, that S.I. Lalkum Sanga, who is the inquiry officer herein, and he's also appeared before the learned CJM in the criminal trial number 15 of 2013, Lordship. And that is also very incorporated statements, Your Lordship.
What is his name?
S.I. Lalkum Sanga,
PW4.
PW4, Lordship. Yes.
He deposed that he being the police officer, he seized the involved vehicle as per law. He visited the place of occurrence but did not find anybody there. Cross-examined, declined. That much only, nothing more. Yes, you may conclude your submission, Mr.
Lordship,
Johnny.
yes,
What else?
I may submit the authority which I rely upon, Lordship.
Yes, what are they?
Yes, I think it's not found in the. Also, that is 2009 13 SCC, page 530. The relevant paragraph is the para 13. Para 13.
Yes.
The learned tribunal, in our opinion, has rightly proceeded on the basis of the apparent that there was absolutely no reason to falsify, implicate respondent number 2 and 3. The claimant was not at the place of occurrence. She therefore might not be aware of the details as to how the accident took place, but the fact that the first information report had been lodged in relation to the accident could not have been ignored. Some discrepancies in the evidence of the claimant's witnesses might have occurred, but the core question before the tribunal and consequently before the High Court was as to whether the bus in question was involved in the accident or not. For the purpose of determining the said issue, the court was required to apply the principle underlying the burden of proof in terms of provision of 106 of the Evidence Act 1872 as to whether the dead was wrapped in the blanket that had been found on the spot at such an early hour, which was required to be proved by the respondents number 2 and 3. In a situation of this nature, the tribunal has rightly taken a holistic view of the matter. It was necessary to bear in mind that strict proof of accident caused by the particular bus in a particular manner may not be possible to be borne by the claimants. The claimants were merely to establish their case on the touchstone of preponderance of probability. The standard of proof beyond reasonable doubt could not have been applied. For the said purpose, the High Court should have taken into consideration the respective stories set forth by both the parties. And another citation which I have read this. Also, this is 2022 SCC online, Punjab and Haryana. Paragraph number 31, Lordship.
Yes.
Section 166 of the Motor Vehicles Act is a piece of welfare legislation. It was enacted by the Parliament to provide relief to the person who suffers injuries in the motor vehicular accidents, as well as to the legal representative of the victims who unfortunately lost their lives in such mishaps. Strict rules of evidence and procedure are not applicable there. That is so why. And also, another citation is 2020 13 SCC, 2020 13 SCC, page 486. Relevant is from page 498, and also 498. From the top, paragraph 24. It will be useful to avert the dictum in such and such case, wherein it was contended by the vehicle owner that the criminal case in relation to the accident had ended in acquittal, and for which reason the claim under the Motor Vehicles Act ought to be rejected. This court negative the said arguments by observing that the nature of proof required to establish culpable rashness punishment under IPC is more stringent than negligence sufficient under the law of torts to create liability. The observation made in part 3 of the judgment will throw some light as to what should be approached of the tribunal in motor accident cases. The same rate as road accidents are one of the top killer in our country, especially when truck and bus drivers operate nocturnally. This proverbial recklessness often persuades the courts, as had been observed by us in other judge cases, to draw an initial presumption in several cases based on the doctrine of res ipsa loquitur. Accident tribunal must take special care to see that innocent victims do not suffer and drivers and owners do not escape liability merely because of some doubt here or some obscurity here. Save in plain cases, culpability must be inferred from the circumstances where it is fairly reasonable. The court should not succumb to niceties, technicalities, and mystic maybes. We are emphasizing this aspect because we are often distressed by transport operations getting away with it thanks to judicial laxity, despite the fact that they do not exercise sufficiently disciplinary control over the drivers in the manner of careful driving. The heavy economic impact of culpable driving of public transport must bring owner and driver to their responsibility to their neighbor. Indeed, the state must seriously consider no-fault liability by legislation. A second aspect which pains us is the inadequacy of the compensation or undue parsimony practiced by the tribunals. We must remember that judicial tribunals are state organs, and Article 41 of the Constitution lays the jurisprudential foundation for state relief against accidental disablement of citizens. There is no justification for niggardliness in compensation. A third factor which is harrowing is the enormous delay in disposal of accident cases resulting in compensation, even if awarded, being postponed by several years. The state must appoint sufficient number of tribunals, and high courts should insist upon quick disposal so that the trauma and tragedy already sustained may not be magnificent by injustice of delay. Justice. Many states are unjustly indifferent in this regard. In the case and such, this court examined similar situations where the evidence of claimant witnesses was discarded by the tribunal and the respondent in that case was acquitted in a criminal case concerning the accident. This court, however, opined that it cannot be overlooked upon the investigation of the case registered against the respondent. Prima facie material showing negligence were found to put him on trial. The court restated the settled principle that evidence of claimants ought to be examined by the tribunal on the touchstone of preponderance of probability. Certainly, the standard of proof beyond reasonable doubt could not have been applied, as noted in Bimla Devi in para number 8 and 9 of the reported decision. The dictum in United India Insurance such and such has been adverted to as under. Right? In United India, such and such, while considering the nature of a claim petition under Motor Vehicles Act 1988, a three-judge bench of this court has called out certain propositions, of which propositions 2, 5, and 6 will be relevant to the facts of the present case. Therefore, we may extract herein below. So that 6 is relevant. The tribunal is required to follow such summary procedures as it thinks fit. It may choose one or more person possessing special knowledge of and matters relevant to inquiry to assist it in holding the inquiry. Also, here in this case also, Salal Kumsanga was maybe chosen for that special knowledge of the matter. And also para number 22, next page. It is thus well settled that in motor accident claims cases, once the foundation fact, namely the actual occurrence of incidents, has been established, the tribunal's role would to be calculate the quantum of just compensation if the accident had taken place by reasons of negligence of the driver of the motor vehicle, and while doing so, the tribunal would not be strictly bound by pleadings of the parties. Notably, while deciding cases arising out of motor vehicle accidents, the standard of proof to be borne in mind must be of preponderance of probability and not the strict standard of proof beyond all reasonable doubt, which is followed in criminal cases. In the present case, we found that the tribunal had followed just approach in the manner of appreciating of the evidence materials on record, whereas the High Court adopted a strict interpretation of the evidence on the touchstone of proof beyond reasonable doubt to record an adverse finding against the appellants and to reverse the well-considered judgment of the tribunal in a cryptic manner. Lordship may take Lordship to the paragraph number 34, Lordship. It's at page 504. Similarly, the issue of non-examination of the pillion rider Rajulal Kratek would not fatal to the case of the appellant. The approach in the examining the evidence in accident claims cases is not to find fault with non-examination of some best eyewitness in the case, but to analyze the evidence already on record to ascertain whether that is sufficient to answer the materials in issue on the touchstone of preponderance of probability. This court in such and such faced a similar situation where the evidence of the claimant's eyewitness was discarded by the tribunal and the respondent was acquitted in the criminal case concerning the accident. This court, however, took a view of the material on record was prima facie sufficient to establish that the respondent was negligent. In the present case, therefore, the tribunal was right in accepting the claim of the appellants even without the deposition of the pillion rider Rajulal Khatek, since the other evidence on record was good enough to prima facie establish the manner in which the accident had occurred and the identity of the parties involved in the accident. And Lordship, there is no regarding that there is no rebuttal evidence and led by the respondents. In this regard, I would like to rely upon the 2014 1 SCC, 2014 1 SCC 244.
Which paragraph?
Paragraph number 31, Your Lordship, which is at page 225. In our considered view, the
Just a minute.
Oh, sir. Sorry.
The citation is page 244. How can the paragraph be 225?
255. Sorry, Lordship. 255. Apologies, Lordship.
255.
255.
Paragraph 31.
31, Lordship. Yes.
Yes.
In our considered view, the tribunal has ignored certain relevant facts and evidence on record while considering the case of the appellant. The High Court, though it has got power to reappreciate the pleadings and evidence on record, has declined to do so mechanically endorse the findings of the fact on contentious issues 1 and 2 after referring to certain stray sentences from the evidence of AW1 and the FIR, and it has erroneously held that there is a contradiction between the FIR and the claim petition and the evidence of the appellants. It has concurred with the findings of the facts recorded on the contentious issues and accepted dismissal of the petition. The concurrence findings of facts are erroneous and invalid, and therefore the same call for our interference in this appeal. The approach of the High Court to the claim to the appellant is very casual, as it did not adhere to the oral and documentary evidence placed on record on behalf of the appellants, particularly in the absence of rebuttal evidence adduced by the insurance company, herein the owner of the accident vehicle. Hence, the same is liable to be set aside, and accordingly we set aside the same. That's it. There is no rebuttal evidence regarding the negligence of the driver. That's it. With this, my ultimate prayer is, Lordship, that the case be remanded back to the learned tribunal to and to set aside this impugned judgment and award, Lordship.
Yes.
May I please, Lordship?
Yes.
My Lord, from the narration of facts, we have heard that the date of accident took place on 17/2/2013.
Yes.
That was Sunday. Then the police report, which is the only available on record, is the police report was made on 12/5/2015. That is at page 9, the police report. The only report available on record is at page 9. And the driver was acquitted by the criminal court on 13 February 2014, whereas the present claim application was filed on 9/2/2018. That means after 5 years from the date of accident, alleged accident, the present claim application was filed, and the impugned judgment and order was passed on 2nd December 2021. My Lord,
Police report is dated 12/5.
12/5/2015, my Lord.
Okay.
12/5/2015, which is available on record at paper book, page 9. And my Lord, accident took place on Sunday. If we go back to the year 2013 calendar, 17 February 2013 was Sunday.
So what happens if it's a Sunday?
Sunday, what I would like to emphasize from this point is that the deceased was the casual paid labor of the BRTF. And BRTF also do have a holiday on Sunday. Usually they don't work on Sunday. They have a break in a week. That is on Sunday. Very surprisingly, the said accident took place while boiling the bitumen to be used on the next day, as per the deposition of the claimant, Parmoy, my Lord. I would like to show your Lordship Page 48 of the paper book is the deposition of claimant number 1, Parmoyi. And I would like to take a lordship to page 53. It may not be necessary to read the whole evidence. Page 53 of the paper book, running page of the deposition of the claimant number 1, Parmoyi, paragraph 13, my lord.
As the deceased is non-local.
My lord.
Deceased is a non-local.
Yes, my lord. Paid labor.
Non-local. He's a non-local.
He's actually his father is I don't remember his father is Budan Soren, my lord, and his mother is a Mizo. So we can say he's a local also.
Okay.
Born and brought up here. My lord, page 13, what I would like to Lalun Lima, yes, my lord. The deceased name Lalun Lima. I'm reading paragraph number 13, my lord. At page 53 of the paper book.
Okay.
My lord.
Father is a non-local. Mother is a local.
My lord.
Page 53.
53, para 13, my lord. With lordship permission. It is a fact that my son's death was related to his employment as casual paid labor, as he was detailed for duty on 17 to 2013 for boiling the bitumen to be used the next day.
Yes.
My lord, what I would like to submit to your lordship is, was it practicable? As we know, the month of February of the year is cold winter. And boiling bitumen to be used the next day, do we really think it is practicable? It is easily, congealed into blobs, like it has become, the boiling bitumen has become semi-solid soon after because of the cold weather. So according to the statement made by the claimant witness, Parmoyi, on 17 to 2013, boiling the bitumen to be used the next day. This is really...
what is the time of the accident?
Time of accident is at 4, according to the claimant Parmoyi. Whereas another witness stated it was 8:30 at night.
PM.
Yes, Lal Khumsanga stated very clearly in his cross-examination at page 60, my lord. Page 60, para 3. Contradictory statement is here. Page 60, para 3. It is a fact that the accident took place at 8:30 p.m. and I am sure that it was at night.
Who is this? Who is this?
Lal Khumsanga, my lord. He is one of the police officers produced as witness.
Okay.
However, according to other witness, Parmoyi, the accident took place at 4 in the evening.
What is the role of Lal Khumsanga?
Lal Khumsanga was the in charge of police Bung Dang South outpost, my lord. He did not have anything to do with the. He was neither the. He was not the IO. He was in charge of Bung Dang South outpost. IO was George L.H. Zava. who was not produced before the tribunal to prove the negligence of the driver, my lord. And my lord, regarding, since the only police report available on record is made by LP Zong Mangaya, Inspector of Police, Officer in Charge, Long Klai, I would like to take your lordship to his deposition and his cross-examination, my lord. His deposition, examination in chief, was read out by my learned friend for the appellant. I would like to take your lordship to page 56, down under, the cross-examination part is found. Cross-examination by the counsel of the OP number 1, my lord. I am reading, it's not very long. Number 1, I was posted at Lunglei as second OC at the time of the accident, that is 2013, and was posted as OC Long Klai sometime in October 2014. Number 2, it is a fact that I had visited the PO after my posting at Long Klai, that is more than 1.5 years after the accident. Number 3, it is a fact that I went and saw the place of accident, but I did not see any reminiscent of the accident. And on the following page, page 57, my lord, paragraph 4, it is a fact that I base my police report exhibited at Exhibit C5 solely on the basis of the investigation report and its documents. Exhibit C5 is the only police report available on record. It was authored by him. According to him, it was on the basis of the investigation report submitted by the IO. However, the report of the IO was not available on record. And my lord, paragraph 5 is, it is a fact that the investigation report is not annexed in the case record, but the investigation report and the case record is with me, even though I have been transferred from Long Klai. It is not known as to why the case record was with him, even after he was transferred from Long Klai. And number 6 is, as per the investigation report, the truck had hit the boiling bitumen, ordinary GCM, which overturned and burned the deceased in the process. That was his statement, without any proof. Number 7, I do not know the distance between the road and where the bitumen was boiled by the deceased. Number 8, it is a fact that I was neither the inquiry officer nor the investigating officer in the instant accident. I was only the person who received the investigation report for on what action. That was his statement, his cross-examination, my lord. And he was the one who issued and made police report, which is Exhibit C5, that is available on record. The only police report available on record is his authored police report, that is at page 9, which I have read out. Here there is no, according to him, it was on the basis of the investigation report. However, the investigation report was not available on record. It was not submitted neither.
What about the FIR?
No FIR has been annexed along with this.
Do you know the date of the FIR?
No, my lord. I have no knowledge because as far as I'm concerned, I only have the records submitted by the claimants as well as the OP.
What about this LP Zomangaya? Does he say that FIR was submitted?
Nothing was mentioned by him, my lord.
Fire was received.
Page 9.
Page 9. Yes, page 9 is the police report submitted by LP Zomangaya, my lord. This was made by him as officer in charge, police station, Long Klai, without anything father, my lord. This police report was the only police report available on record. And my lord, Lalkum Sanga was another witness who was produced before the tribunal. His examination in chief was read out by my learned friend, and his cross-examination is, this also has been read out. So it may not be necessary to read again, my lord. These two depositions made by the police officers does not have any basis as there is no FIR, nor charge sheet, nor report made by the IO, George L.H. Zawa, my lord. The only police report available on record, as we have just read out, is police report is made by LP Inspector LP Zohmaya. Here, it is not very long. I'm reading with a lordship permission. Page 9.
Mr. Liantrima,
Yes, my lord.
can we continue tomorrow, this matter?
No problem, my lord.
I have a meeting at 4 o'clock.
Oh, my lord.
I'd like to rise.
There is no urgency at all with regards to the present case, my lord.
Because I don't want to hurry up everything. So, after your submission, Mr. Johnny might want to have a reply.
Right, my lord. Actually, apart from the police report available on record, which we have just read out, nothing more to see, my lord. Evidence also that much. Nothing more, nothing less. Anyway, to satisfy ourselves also, we can come back tomorrow, man.
Report. Are you going to rely on his citation?
Yes, my lord.
Okay. You have given the list of books.
Yes, my lord, I have. Proof of negligence required as per the Supreme Court ruling in Surendra Kumar Arora and another versus Manoj Bisla and others, reported in 2012, volume 4, SCC, page 552, para 9, my lord. Para 9.
It's okay. We'll have it tomorrow, huh?
My lord.
Please write down hard in part. List again tomorrow for hearing. Please give the date. These can remain as it is. I'll use it again tomorrow.